No, no. After vacation on the first Monday, if my lord fixes, well, I'm a
What
new
do you mean
entry.
fixes? We can't fix anything. It will be there in the list. It will be there, Mr. Datto. Take your chance on the reopening day. There won't be too many lawyers in our
Be there.
assessment.
May I only request your lordship one thing. I am not troubling your lordship.
Yes.
My lord, as my learned friend said, my lord, after vacation any day, my lord, kindly.
We can't fix, Mr. Datto. Sorry. It disrupts a lot of things. Then we have to fix every matter. Why only your matter?
No, because your matter had taken up one day,
We had taken up many matters on one day.
but here your lordship directed
No,
us
sorry,
to
sorry.
get ready with the notes of argument. These are all ready.
Mr.
Well, it
Datto,
will-
come on the reopening day.
I will
There's
come.
a fair chance of this matter being taken up. As I said, in our assessment and in Mr. Kaur's assessment, not too many learned lawyers will be present. We are reopening on a Friday,
Yes, that is.
right?
I am
So-
will be there.
most damaging day, my lord, Friday. Monday, my lord, keep it on Monday, my lord, kindly.
We won't dismiss on the reopening day.
No, I know, my lord. But if it is better, my lord, your lordship, kindly on Monday.
Very
Friday
well.
হলে
Keep
কোনো
it on the 27th. 27th.
Blessed.
Lord, I was seeking my lord's leave to mention a matter. Lord, there was a time, Lord, for furnishing the bank guarantee till today. Lord, I am seeking a week's extension. This is a section 37 application, which your lordships admitted. And Lord, your lordships, Lord, directed us. Kindly, Lord, come to second page. The around the middle, little below the middle. Today, the respondent says that amount due is approximately such and such. In view of the law that prevails today, the appellant should secure the balance amount. The appellant shall furnish a further bank guarantee for the sum of rupees 3.35
Yes,
crore.
yes. The time expires today.
Today, Lord, I'm seeking a week's extension.
Other side?
I've served notice, Lord. It is, I have served notice. Lord.
Who is appearing? Shogboshachi Chaudhuri,
Chaudhuri was there.
Rajoshi Dotto, Shaunak Mukherjee. এক সপ্তাহ extend করে দিই, notice তো দিয়েছি। This matter, you're appearing. This matter, লেখো। This is, no, not a listed matter. 27th October listed হবে। Supplementary করে দাও। এইসব ফ্যাচাং শুরু হয়েছে। Unless it is in the list, it can't be uploaded.
Oh.
So he'll take out a supplementary list. Come back at 1 before we rise.
Very well. I'll do that. Lord, I'll serve a notice and
হ্যাঁ বেঞ্চ আছে 12:30 বেঞ্চ আছে এটা তো 1 মিনিট লাগবে I have a different bench at 12:45 so we'll rise 2 minutes before that come at 12:40 this will take 1 minute
I'll be.
and if you find any of your learned friends
I'll
also
talk to Mr. Shoboshachi Chaudhary.
Yes.
I'll try to, Lord, tell him.
এটা রাখো
Much obliged. I can notice the
লিস্টে বার করে দাও
May your lordship's kind leave to mention, your lordship, a non-commercial division matter, item number 58. Suit has been dismissed, your lordship, for your lordship revocation of section 12A. Now the problem, your lordship, is this.
and what survives of the appeal
No, suit has been dismissed, your lordship, by
appeal
revocation.
from that
Against that, your lordship,
Twice.
we have preferred an appeal. Now, your lordship has heard the matter, your lordship, before your lordship, the summer vacation, but could not be taken up. It's an assigned matter because it came before the other bench, your lordship. Then we wanted to do the matter before in front of the Honorable your lordship and Honorable Justice Rai. Item 58, your lordship. My urgency is only, your lordship, only getting, I was enjoying an interim order. Now they are flooding the market with the goods, your lordship. My problem is that I cannot go before the mediation now. And
better we release it from our list you have it assigned to some other bench we can't give precedence to every matter Mr.
No, no,
Shobhasha. It's not possible
any date, your lordship, any time,
then we have to fix every matter on a particular day at a particular time.
as your lordship thinks fit, some precedence, if your
Sorry.
lordship kindly give.
So we have told them each category by rotation
Lordship.
on a day. এইগুলো করছো তো হ্যাঁ স্পেশালি অ্যাসাইন কোনোদিন তো উপরে দেখতে পাই না
Though it's a commercial division matter, your lordship, but still, your lordship, it's a assigned matter. That's why it's coming under.
স্পেশালি লিস্টের আগে দেবে একদিন স্পেশালি অ্যাসাইন উপায় তো নেই টিউসডে করে কোনো লাভ হবে অ্যাপেলেট সাইড ডেতে? তাই করো, ওয়েডনেসডে করো না, ফ্রাইডে করো। কমার্শিয়াল মানডে তো টপে থাকছি, মানে কমার্শিয়াল, ওইটা নন কমার্শিয়াল, ওয়েডনেসডে করে দাও।
Actually said commercial matter, but your lordship it has coming under the heading as assigned matter.
Let us see if we can do it before vacation. Otherwise, after vacation, mention again what can we do. Whether we'll have the determination after vacation also, we don't know.
But it's an assigned matter, so maybe possible.
Assigned.
The matter will follow your lordship.
Let us see.
I'm grateful. Yes.
Non-commercial matter, item number 1.
Appellate side. Oh, Dr.
I appear on behalf of the appellant petitioner. I mean, this is an appeal, from an order, dated 29th July 2025. I beg your pardon, 28th July 2025, which was granted ex parte, and which resulted in the receiver taking actual possession of my vehicle. If I may briefly indicate the facts, before I place my challenge to the impugned order. The loan was sanctioned, in July, on the 28th of July 2024. Loan amount was 13 lakhs with a EMI of 36,843. From time to time, I made payments. I was diligent in that regard. However, in May, there was some issue with payment, as a result of which they issued us a notice under the Payments and Settlements Act on the 30th of May 2025. Subsequently, they issued a loan recall notice and invocation of arbitration notice on the 11th of July 2025. Up till this date, I was in the know of the proceedings and what was going on. However, on the 25th of July, as would appear from the case status, I was not aware, a Section 9 petition was filed by them. That was taken up for hearing on the 28th ex parte, and the impugned order was passed. I'll place my challenge to the impugned order later. However, if I may just submit this, 28th of July, the order was passed. The order has still not been served to me. The Section 9 petition has still not been served to me. For over a month, when they had stated there was a grave urgency, for over a month, the order was not enforced, no action taken in that regard. However, suddenly on the 2nd of September, a purported agent of the receiver comes to my place of residence and takes possession. In the interregnum, between the 2nd of August and the passing of the impugned order, they issue us a notice with regard to conciliation proceeding. They send us a link for the first meeting on the 15th of August. I was not, my learned advocate on record who appeared on behalf of me, was not allowed entry. I issue him a letter on the 18th. Informing him that I was not allowed and requesting that I would be allowed on the next day. And here, a very important fact is put on record. That being that I had been in discussion with the officials of the respondent with regard to a certain restructuring in order to make good my debts. And here, I must state this, at that point in time, I was with full intentions of making good my debts, and as on this date, I am with full intentions of making good my debts. In these conciliation proceedings, which were admittedly, the correspondence of which was admittedly issued post the impugned order, there was no mention of the Section 9 petition. There was no mention of the impugned order. All of a sudden, the impugned order there was enforced. Now, may I kindly trouble my lords with the impugned order. If my lord may kindly take the memorandum of appeal, the grounds end at page 5. The order is from page 6. Well, it's a short order, if I may place it. My lord, if I may place it, my lord, it's a short order. May I place it in its entirety?
No, because we have read it in its
lord.
entirety.
My lord, may note the perverse.
Therefore, tell us what is perverse about
My
this order.
First ground, my lord, absolutely no reasoning. Second ground, my lord, not even findings with respect to, my lord, the requirements for granting an injunction. Third, my lord, the relief that was granted, my lord, was not just and convenient. The relief, my lord,
Yes.
the
Remove yes.
the vehicle could very well, my lord, the interest in the vehicle could very well have been protected, my lord, by an order of injunction against me from disposing it off, or, my lord, a symbolic possession. This was not, my lord, a just and convenient order. And, my lord, most importantly, this ought not to have been passed ex
Who
parte.
started all this problem?
My
Who's
lord,
the defaulter?
my lord, I will say this. My lord, I understand
will
what
you
is
say?
stopping. I understand what is
Nothing
stopping.
to say.
My lord, may I say this? May I say this, my lord? Even if there has been a default, my lord, arbitration proceedings will be invoked. I am in conciliation proceedings with him. At this point in time,
go back, sir, go back.
my lord,
Go back before the learned trial judge. We leave everything open. If you want to pay, tell the learned trial court you want to pay, do whatever you like. We see no perversity in the order.
My lord, may I kindly, my lord, place, my lord, one or two judgments, my lord. First of all, my lord,
Cost.
may I, my lord, place one judgment, my lord. My lord, this is a judgment, my lord, of our division bench, 2000 Calcutta. 2000. My lord, may I kindly place one thing from the impugned order? My lord, I say this, my lord, there is not even a finding, my lord, that there is a likelihood of me dealing with, my lord, the vehicle. May I place, my lord, may kindly take, my lord, the third last paragraph, my lord, on the from the first page of the order. It appears from the agreement that all disputes are to be referred to an arbitrator appointed by the petitioner. In this case, the arbitrator has not yet been appointed by the petitioner in terms of the relevant agreement. It also appears from a record that a huge amount of money is still due and payable by the respondents to the petitioner in terms of agreement. No, but may I, my lord? It
Yes.
It further appears that the demand notice has already been served by the petitioner on the opposite party, but in spite of the same, the opposite party did not pay outstanding dues. My lord, here it's important, my lord. The next sentence I read, my lord, is not even a finding of the judge. It is a recording of a statement in the petition. It is stated in the application under Section 9 of the Arbitration and Conciliation Act that the respondents with an intention to defeat and or obstruct the realization of dues and or recovery of the possession of the said vehicle would dispose of and or encumber the said vehicle to some unknown place and or remove the valuable component parts thereof. This, my lord, is a mere recording of a bald statement made in the Section 9 petition. Not even a finding, my lord, of the learned judge. In such a circumstance, my lord, could such a coercive ex parte injunction, my lord, order be granted? My lord, is a question I ask myself. I'm armed with one judgment, and my lord may kindly.
Show us the judgment.
My lord, this is a division bench of, my lord, the Calcutta High Court. My lord. I may indicate, my lord, there's a Supreme Court judgment, my lord, the Chadda's case, which I also formally rely on, but I will place, my lord, while placing this in. Give a copy. The citation is 2000 SEC Online, Calcutta 43. I'll, my lord, hand up a copy shortly, my lord. Yes. My lord, this was, my lord, an a proceeding arising from an ex parte Section 9 order. My lord will see that, my lord, from paragraphs 1 and 2. My lord, paragraphs 10 and 11, my lord, they deal with, my lord, principles which I will, my lord, kindly take, my lord, straight to paragraph, my lord, 50. The Supreme Court made it clear, if I may place, my lord, paragraph 15 at, my lord, print page 6. The Supreme Court made it clear that the proviso was introduced in Rule 3 of Order 9 of Order 39 to provide a condition where court proposes to grant an injunction without giving notice of the application to the opposite party, being of the opinion that the object of granting injunction itself shall be defeated by delay. Here, my lord, here the Supreme Court held that the condition so introduced is that the court shall be record the reasons why an ex parte order of injunction was being passed in the facts and circumstances of a particular case. The court held that in this background, the requirements of recording the reasons for grant of ex parte injunction cannot be held to be a mere formality. The court held that the requirement is consistent with the principle that a party to a suit who is being restrained from exercising a right which such party claims. So, my lord, I'll not trouble my lord. My lord may kindly come, my lord, to paragraph 16. My lord, this is reliance, my lord, on Chadda's case. My lord, which I also reliance. I will hand up a copy, my lord. My lord, Chadda's case was considered in Morgan Stanley Fund versus Kartik Das, reported at 1994 for SCC 225. In paragraph 36 of the reported decision in Morgan Stanley's case, the Supreme Court laid down the factors which would weigh with the court in the grant of ex parte injunction. The said paragraph 36 is quoted herein below. As a principle, ex parte injunction could be granted only under exceptional circumstances. The factors which would weigh with the court in the grant of ex parte injunction are whether irreparable or serious mischief will inure to the plaintiff, whether the refusal of ex parte injunction would involve greater injustice than the grant of it would involve. C, the court will consider the time at which the plaintiff first had notice of the act complaint so that the making of improper order against a party in his absence is prevented. D, the court will consider whether the plaintiff had acquiescence for some time. In such circumstances, it will not grant. I apologize.
How much has fallen due now? As on date?
3 lakhs, 3 lakhs, my lord. More than 3 lakhs.
Pay.
My lord, may I say this? May I say this?
We will not pay.
My lord, I have every, my lord, I
No,
say
you
this.
may
with
have
conviction.
intention. We are not interested in your intention.
My lord,
We
my lord,
want
why-
to see the money.
my lord, why I say intention, my lord? Sorry.
Pay. Physical possession will be given to you. The receiver will remain in symbolic possession. Injunction against you not to deal with the car. Use it.
My lord, may I submit two things?
Take it or leave it.
My lord, may I kindly, my lord, may kindly permit me to submit two things. Why I say intention? My lord, I will, if my lord may forgive me, my lord, place, my lord, a single bench of the Delhi High Court, which relies on a division bench of the Madras High Court with regard to seizure of properties. There, my lord, it says where it is clear that there is no intention to pay the dues, only in such circumstances should actual possession be given. And my lord, if I have paid the entire amount, how much can I secure?
Do you say money has not fallen due?
I am not saying that. I am
Money
saying,
has fallen
Well-
due and you are not paying. Does it
Well-
not show the intention of not
Well-
paying?
my lord, it shows, my lord, a delay.
We are
I-
unnecessarily discussing this.
No,
If
no,
you have
my lord.
intention to pay, money has fallen due,
My
you
lord.
are not paying. Do
My lord, there is a situation,
don't match at
my
all. You have intention to pay,
my lord,
you are not paying.
my lord, this,
Still you have intention to pay.
lord,
We
this
are
is-
unable to.
my lord, this is a
see
situation,
corner.
perhaps, my lord, I should have
Sir,
been clearer.
costs are going up only. Let us warn it.
Just 5 minutes on. My lord, this is a situation where, my lord, a restructuring has become necessary for the purposes of which I have already been in discussion with the officials. There was, my lord, a prima facie agreement reached Second, my lord, conciliation proceedings are going on. In such circumstance, my lord, there is no likelihood whatsoever, my lord, that the vehicle will be, my lord, disposed of my possession. That, my lord, undertaking, my lord, my lord, of course, give, my lord, may kindly, my lord, give symbolic possession. However, my lord, this is a coercive order, my lord, which is extremely prejudicial to me, my lord. And my lord, especially in such an order, my lord, one, my lord, point I missed. This ex parte order was passed and, my lord, listed next, my lord, in January of next year. My lord, this was a tactic. My lord, may kindly consider this. My lord, may kindly allow symbolic.
My lord, may pass usual order directing rested me not to sell the vehicle, my lord. They will approach the trial court for modification.
My lord, may note, my lord, this is something I use
Sir,
for my
what
profession.
we'll do,
My lord.
we will indicate that if they pay you the amount that has fallen due,
My lord.
then physical possession will be given back to him.
My lord.
The receiver will be in symbolic possession.
My lord.
He is restrained from dealing with the vehicle. And then further proceedings before the trial court just carry and arbitration.
My lord, I am grateful.
My lord,
In-
for,
An application. This is an appeal. Section 57.
my lord, 3 lakhs. May I submit this?
We are dictating an order, Mr.
I apologize, my lord. I apologize.
Take your seat. Take your
Right.
seat.
Appeal under section 54. The challenge. Right. Asking. Case number 177. By 11th bench, City Civil Court at Calcutta. Paragraph. Happened taken the field of a credit facility for the principal sum rupees 13,00,000, rupees 13 lakh from the respondent, which was to be paid off equated monthly installments on the appellant defaulting in repayment of the installments that had fallen due on respondent issued a recall notice calling upon appellant to pay up the outstanding dues, full stop. The appellant failed to honor the demand made by the respondent, full stop. The respondent therefore approached the learned City Civil Court of Calcutta by way of an application under Section 9, the Arbitration and Conciliation Act 1996, praying for interim orders seeking protection of the vehicle that was purchased using the credit facility availed of by the respondent, by the appellant from the respondent. With 13 lakh for the purpose of purchasing a vehicle. Hypothecation to the respondent. The said application was pressed ex parte at interim stage, full stop. The learned court, upon being satisfied by a prima facie case made out, by a strong prima facie case made out in the application under Section 9, observed as follows. It appears feeling aggrieved by the said order, the present appeal has been preferred by the appellant. Full stop. Paragraph. Mr. Acharya, learned advocate appearing for the appellant, submits that the order impugned has no legs to stand in as much as the same is bereft of reasons. Full stop. Submits that in view of the law laid down by the Honorable Supreme Court, the case of Shiv Kumar Chadha, following Morgan Stanley, no ex parte ad interim order of injunction to have been passed without supporting the conclusion by cogent reasons.
Yeah, understand. Chadda was discussing.
After 93, after 94. It's further submitted that the appellant had every so conciliation being issued by the respondent. The appellant had participated in such proceedings.
Second such conciliation proceeding, I was allowed entry. Two meetings, one meeting I was not allowed, second meeting, I participated.
Conciliation. The appellant got chance to participate in one of those. The advocate appearing for the respondent submits that as on date a sum of rupees.
My lord, approx 3 lakhs, my lords.
My lord, here,
Approx, my lord, I have not exact
page
amount.
61, my lord, their invocation notice, outstanding installment amount is 1,32,908.
What is the date of that notice?
11 July, my lord.
11 July.
My lord.
Today we are in September.
My lord.
It must have gone up.
It could not have gone up to 3 lakhs is my lord submission.
Whatever the amount is, we are not. Approximately 3 lakhs, they are saying paid.
The outstanding installment amounts, may kindly.
A sum of rupees 3 lakh approximately is due and owing. This is the total due.
Oh, my lord,
The installment.
principal, my lord, is a principal, my lord. There is a other 13 lakhs above, my lord, this is total amount. More than 13 lakhs, my lord.
From the appellant in the principal sum. Full stop. Mr. Bhattacharya, however, submits that in terms of the notice dated July 11, 2025,
861, my lord.
appearing at page 61 of the application for stay. The total outstanding due as on the date of notice as on July 3, 2025 was rupees 1,35,9151.58.
9151.
Well, that is the total considering recall, my lord, if I may.
Since we have terminated, my lord, we recall the loan.
My lord, may kindly consider the first entry, my lord. I apologize. First entry.
That is the installment due.
My lord, indeed, my lord. Total installment.
Okay. I indicated 132,908. The installment due on termination is 12 lakhs.
My lord, that is because of recall of the, my lord, entirety of the loan.
As on date, that is due because they have recalled the loan on default.
My lord, consider, my lord, if I may submit, my lord, it would serve.
This is why you should have been reasonable in accepting that.
My lord, we were in the process of conciliation proceeding. That is what I'm submitting, my lord.
We have heard the learned counsel appearing for the respective party, considered the material on record. Full stop. Paragraph. A reading of the order impugned does not show that the order is fully bereft of reasons. Fully not is bereft of reasons. The learned court has recorded that there appears to be a strong liability case being satisfied by the pleadings made in the application under Section 9 of the Arbitration and Conciliation Act 1996, filed by the respondent. Full stop. It is not in dispute, even before us, that the appellant has indeed committed default in payment of the loan, repayment of the loan that has been availed of by the appellant from the respondent. Full stop. Paragraph. Although it has been submitted that the appellant has every intention to square off the loan, on our query as to whether the appellant was ready and willing to pay the amount that has fallen due as on date, the installments that have fallen due and amount of installments that have fallen due as on date, we did not get an answer in the affirmative. Full stop. Paragraph. This does not betray a bona fide intention to pay up. Full stop. Be that as it may, it is settled that if a challenge is made to an ex parte pedantry order of injunction, the appellant is to confine to the pleadings and the documents that were there on record before the court which passed the ex parte pedantry order of injunction. Full stop. We are we being the appellate court are unable to take cognizance of any new document or any new case that can be set up or be made out before us. Full stop. On the pleadings made in the Section 9 application, we do not find that there is any infirmity in the order impugned.
My lord, the Section 9 petition is not on record, my lord. Because I have not been served till date, my lord. Till date, I have not been served. Till date, I have not been served. I came to know, my lord, when the order was being enforced. An ex parte order was being enforced.
Pleadings recorded in the order impugned. Pleadings recorded. Paragraph. The appellant shall be at liberty to approach the learned court by way of an appropriate application seeking vacation of the order dated July 28, 2025. Full stop. We make it clear that in case the appellant pays up the installments that have fallen due as on date, the receiver shall only be in symbolic possession of the vehicle and not in physical possession, upon such payment being made. Full stop.
Wait, clear করে দাও, upon such payment being made, the physical possession will be returned.
The physical possession by the receiver shall be returned to the appellant upon the aforesaid upon payment of the installments that have fallen due as on date being made. Full stop. Paragraph.
Injunction.
However, the petitioner, the appellant, in such case, shall remain injuncted from dealing with, alienating, or creating any third party interest in the said vehicle till such time that the section 9 application is disposed of by the learned court. Full stop. Have you taken out arbitration proceedings, initiated
My
arbitration?
lord, I have no instruction regarding that.
They have invoked,
Hmm.
my lord, and they have also, my lord, invoked, my lord, conciliation proceeding in the meeting. They've sent a invocation of arbitration notice.
They have sent it.
My lord, the 11th July letter that I placed, my lord, that is a loan recall, my lord, come invocation notice. I am not submit, my lord, it's not in proper form of 21, my lord, that I may make at the appropriate stage.
FMAT of CP of 2025 stands disposed of along with Can 1 of 2025 আর একদম উপরে লিখে দিলেন by consent of parties the application was
আমি একটু লাইন অ্যাড করে দিচ্ছি ডিসপোজালের আগে ঠিক দেখো we have not all observations made in this order are prima facie and only for the purpose of deciding this appeal. Stop. The learned trial court shall decide the section 9 application in accordance with law without being influenced by any observation in this order. Stop. It will be open to the parties to make further appropriate prayers before the learned trial court. Stop. Paragraph. Disposed of koro. Tarpore lekho. We were minded to award costs against the appellant as we find no merit in this appeal. Stop. However, the eloquence of learned advocate for the appellant persuades us not to do so.
Grateful. My lord, just one point, my lord, may be disposed of after hearing the parties, my lord, because
Of course.
my lord, because this is
goes
This
without
is
saying.
in accordance with law, observing the principles of natural justice.
grateful. I'm deeply obliged.
I'm grateful.
Lordship, I beg to appeal.
Same order.
Same order, only the amount will be differential. Lordship.
হ্যাঁ, কালকে কয়েকটা অর্ডার রয়েছে তুমি জানো কি অপূর্ব নিয়েছে তুমিও একটা করেছো
Lordship, may I have your Lordship's kind indulgence?
this are you going for mediation? No.
No, may I, your Lordship? Well, I'm similarly circumvented as the item number 1, your Lordship.
Item number
default-
1.
One, your Lordship has ordered.
Today's list.
Yes, today's list. Just the earlier matter. Lordship has ordered for payment of the installment overdues. Lordship, I've got instructions from my client. My client, what has fallen from my client is that till date, an amount to the tune of rupees 2,13,474 has fallen due. May I hand over the statement of accounts, your Lordship? Sir. This is the net receivable amount. This is devoid of the future installments. Your Lordship, if only they pay this installment, then let the receiver be in symbolic position. We shall return the vehicle. He'll ply it in its usual course of.
Physical position has been taken.
Yes, it has been taken.
There's the একই order.
Similar order as the item number 1, your Lordship.
Yes, it
Because
with
mediation
appropriate
would be
changes.
more waste of time.
বুঝেছো? নাম অ্যামাউন্ট নোটিশ ডেট পেড সব হ্যাঁ পারবে তো
Lord, regarding the quantum of amount, Lord, kindly come to their records, page 22.
It was at the
Lord-
time of filing of the section 9
Lord,
application. Now it has
whatever they are
increased.
claiming, Lord, and in addition to that, the current EMI, I shall pay, Lord. I am ready to pay. Lord,
whatever has fallen due by way of installments in the form of installments till date.
Lord, then kindly give me some installment to pay the amount. Otherwise, 2 lakhs at a time, I may some.
Installments you have defaulted. Now for the defaulted amount you are paying for installments. ঠিক করে দাও আগেরটা যেটা ছিল করে দাও with appropriate changes তারপরে আমরা দেখে নেব same thing
Well, the amount.
there is no question of mediation here
No, there's no question because only the if they pay the amount, I'll release it. He'll use it in the course of this business.
and the receiver will be only in symbolic
Symbolic
position he is injuncted from dealing with it
Yes.
and the further proceedings before the section 9 court না কস্ট ফস্ট গুলো এটা বলো না কস্ট ওই প্যারাটা দিও না খালি we were minded to avoid costs ওটা দিও না yes Mr. Ghosh same thing এবার অরিজিনাল সাইডটা একদম ওয়ানটা কন্ডোনেশন অ্যালাউ করে দিও আইটেম নাম্বার 2 তে and ওয়ানটা অ্যালাউ করে
Commercial division, you have taken item number 1.
My lord had earlier called for a report in respect of 8 lakhs. Then my lord, it transpired that there's 3 lakhs plus 3 lakhs, which is already there. So my lord had again called for a report in respect of those. My lord was considering the stay petition in respect of
Mijam
Mihija.
দেখি আরেকটা রিপোর্ট চেয়েছিলাম দিয়েছে দেখো
13 lakhs, say 3 lakhs. It was not.
what was the date of the last order
My lord, last order is dated
25th August perhaps
29th August, possibly, my lord.
29th.
Your lordship, once I can hand over.
29th August.
Thank you.
so 2-3 lakhs
Yes.
2-3 lakhs
2-3 lakhs.
হ্যাঁ তাই এটাই লিখছে রিপোর্টটা না না এই রিপোর্ট তো পুরনো রিপোর্ট 28th August আমাদের অর্ডার তো 29th August হ্যাঁ তো এইটা তো রিপোর্টটা তার আগের রিপোর্ট নেই কমিউনিকেটেড হয়েছিল
আচ্ছা, এখানে আছে।
Of course, we did not ask the parties to communicate. Did you, by any chance, communicate to the
Not,
registrar?
no, my lord, because the previous
Good
directive,
point.
my lord, we had communicated, but
দেখেছিস এটা তো আগের রিপোর্ট No, we don't have the report, so let it come on
Monday then, my lord.
Monday.
Monday. Will it come so soon? As in, if it's not yet been communicated?
No, communicated. It
Oh,
has been
oh, well.
communicated. কবে communicate করেছো? 29th এই। It's very unusual because our registrar original side is very diligent. Something has happened. We'll look into it. We'll look into it. Let it come on Monday.
On Monday, my lord.
Huh?
will come.
We'll just say not today.
Grateful.
We'll just say not today and we'll একটু জিজ্ঞেস করো কারণ show
My lord,
We had called for a further report from the registrar, comma, original side, comma, Calcutta High Court, learned registrar. Stop. Paragraph, we do not today, comma, we do not find such report on record. Stop. Paragraph, list this matter once again on Shamne Shukurbar kore dao. Stop. We hope that on the next date, the report that we had called for will be before us.
By abundant caution, my advocate on record will communicate.
Paragraph, let copies of the orders, copy of the order dated August 29, 2025, as also a copy of this order be forwarded by learned advocate on record for the appellants to learned registrar, original site, Calcutta High Court.
Grateful, my lord.
Immediately.
Grateful.
Item number 2.
My lord, Mr. Devdut Mukherjee is appearing in this matter, my lord.
Mr.
Devdut Mukherjee, my lord.
Yes.
He's engaged in another court, my lord. I'm humbly praying for a short passover, my lord.
Item number 3.
My appeal, my lord. My lord, here, my lord,
There is no application.
no application is required, my lord, because, my lord, Order 12, Rule 6, my lord, we are coming, it was dismissed, my lord. We're
Achha.
stopping on appeal.
Appeal has to be heard. All
My
My lord, I'm
people,
appearing for the respondent in this matter, my lord. May I raise a
the
few points
plaintiff,
as regards
appellant
the
plaintiff.
maintainability?
Appellant plaintiff, my lord.
My
Hey.
lord,
How, when will you file paper book?
My lord, 3 weeks after, 2 weeks after.
2 weeks after.
my lord, I have a small objection as regards the maintainability point is concerned, my lord. Before the trial court, they had filed an application under Order
কিছু
12
শুনতে
Rule 6.
বুঝতে পারছি না ভাই। একটু বাড়ানো যাবে? Why are you not in court, madam?
My lord, there is a bereavement in the family, my lord.
Oh, we are sorry to hear that. We can't hear you clearly. That's the problem.
My lord, if your lordship can hear me clearly now, am I audible?
Yes, what are you saying? This appeal is not maintainable.
My lord, why I'm saying so is that before the trial court, they had filed an application before or under Order 12 Rule 6, and similarly, we had also filed an application under Order 7 Rule 11. Both the application had gotten dismissed. From there on, from that rejection, they had filed this appeal. If your lordship kindly takes, this was a suit under commercial division. If your lordship, I'm led by Mr. Dasgupta, my lord, in this matter.
He's making submissions. The point is same, that it's an appeal is not maintainable. It arises out of an order which is not applicable under Order 43 in terms of the Commercial Courts Act.
Order 12, Rule 6.
It's a rejection of that. It's not an appeal under Order 43. That's the simple point here.
No, there is no cross appeal, my lord, on that effect, my lord.
There is no cross appeal.
I'll address that. I'll address that and
Forget
the
about
reason
that.
why I'm saying it.
Think about your appeal.
Yes, my
Think
lord,
about
I will,
your
my lord. I will, my lord.
The remedy elsewhere, my lord, not here. The Supreme Court ঘুরে এসে
Ah, then why should we direct paper book to be filed? And
And
keep
we'll
an
hear
appeal
on that
pending?
issue, my lord, we'll address, my lord. The reason, my lord, is there, my lord, because, my lord, I'm coming up with with a statement, with
Clause 15 is out.
yes, my lord, only, my lord, difficulty, my lord, what I'm facing, my lord, here, my lord, that is that the issues, my lord, which was raised, or the points which was raised, my lord, those, my lord, judgments are not there.
No, you may be facing difficulty, but the statute is a statute.
It helps
Parliament
not
has to amend it before your difficulties are solved.
Well, I'll come back, my lord, with the issue, my lord. I'll just look into it and come back.
What possibly can you tell us?
I'll come back with the issue, my lord. Let me come back,
Monday?
my lord. Let me
Monday?
Monday will come back.
Monday. এই লেখো একটা order করো.
Supreme Court ঘুরে
This appeal is directed against a judgment and order dated June 25, 2025, passed by a learned judge of this court in the commercial division, in GA Com number 4 of 2024, filed in CS Com number 412 of 2024. Stop. GA Com 4 was your application?
No, my lord. GA3, my lord, was back.
Achha.
Composite order.
তাহলে GA4, GA3 of 2023 and GACOM 4 বুঝতে পেরেছো? ये GA3 of 2023 and GACOM 4 of 2024 filed in CSCOM যেটা বলেছিলাম 412 of 2024. Stop. Paragraph GA 3 of 2023 was the defendant's application for
That was the
Plaintiff's application.
sorry, was the appellant's application for judgment upon admission under Order 12, Rule 6 of the Code of Civil Procedure. Paragraph GA Com number 4 of 2024
application.
Was an application filed by the defendants in the suit under Order 7, Rule 11 of the Code of Civil Procedure, comma, for rejection of the plaint of the suit. Paragraph. By the judgment and order impugned, comma, the learned single judge has dismissed both the applications. Stop. Hence, the plaintiff has come up by way of this appeal. Paragraph. Learned advocate appearing for the respondents/defendants says that this appeal is not maintainable on a reading of Section 13 of the Commercial Courts Act, 2015, read with Order 43, Rule 1 of the Code of Civil Procedure. Paragraph. Learned advocate for the appellant seeks a little time to consider this issue and come back. Paragraph. List this matter once again on Monday or Friday?
Friday, Monday.
Friday পালিয়ে যাবে কোথাও Monday date দিয়ে দাও last week.
No.
আরে আমিও আসতে পারছি না অ্যাপিল ওই জন্য
আসতে হচ্ছিল না
I also
আসতে পারবো না
this is the same. I also can't file an appeal.
No.
Yes, sorry.
That is the reason why I also can't prefer an appeal from that order before this court.
This is A.K. Upadhyay advocate. Is your advocate on record? He is BA, LLB, LLM, GGU, California. What is that?
I have to ask him. I don't. Ask him, my lord.
Come back with that instruction.
I will definitely, my lord, come back with instruction.
Grateful.
Lot of degrees are done, my lord, in the COVID times. My lord.
My lord, I beg to appear for the appellant.
Appear for
not
the
appellant
respondent.
plaintiff. I appear for the appellant plaintiff, my lord. This is my suit for recovery of money arising out of a settlement agreement. But what has happened, the appeal has a very small scope. My lord, what has happened? My lord, I have taken out the suit in commercial suit division, my lord. I've taken out the suit in commercial division. My lord. Thereafter, I obtained an injunction order on 13th December 2023, whereby the defendant's bank account was injuncted from operation. Thereafter, time to time, the injunction order was extended. After
Injunction restraining the defendant from doing what?
operation of the bank accounts.
Acha.
Thereafter, they had taken out an application GA4 of 2025 saying that it is wrongly instituted in the commercial division. It should be in the non-commercial division. I concede to that point. I said it can be transferred to the non-commercial division without being rejected. And basing upon the judgment given by the coordinate bench that I have annexed at page 106, and only the scope of this appeal is that while placing of this order, I had praised that the suit that was instituted before the commercial division be renumbered as be given a new number in the non-commercial division on the basis of the judgment that has been relied on. But that has not
Our
been done.
judgment?
No, that was given by Honorable Justice Somensen and Smita Dasde.
এই দাও কি এটা দাও তো এই পিটিশনটা দাও আচ্ছা আগে এটা পড়ি ডিফারেন্স
The short question is whether it can be the plaint has to be returned and presented.
What is the division bench order? I have only relied upon that. Only the direction that has been given.
I'll address your lordship on that.
See, the difficulty is, do you have the practice guidelines with you?
Practice guidelines.
Commercial code?
I can obtain it online.
Clause 4. Subclause 2.
Yes, ma'am.
Clause 4, subclause 1 talks about transfer
Transfer.
of suits pending as on the date of the
Coming
act,
into effect of the act.
Yes.
right? But clause 2 says nothing will apply to any suit filed after that date of coming in.
That is in line with section 15 of the Commercial
That is
Codes
the
Act.
problem. Otherwise, it could have been transferred.
The only thing, this is a change of name nomenclature, man. No one will be
Understand what
affected if
happens?
it's changed. But only thing, if the non-commercial goes to commercial division, comes the time limit of WS and all that. But if the same changes to non-commercial, there will be no effect.
These practice guidelines have some value.
But very well, but my lord, I can only rely upon the judgment that I have been had.
That
I
did
cannot.
not consider the practice guidelines.
The
On the
Chief
contrary,
Justice has the power under Section 4 of the Commercial Codes Act. It is a wing of the ordinary original jurisdiction.
Sir, in fact, my lord, in paragraph 17 to 20 of the judgment, my lord,
It is right that it cannot be transferred to commercial, but it can be filed commercial. It is to be transferred to. Then if this
ওখানে কি ছিল? কোথায় ফাইল করেছিল? এখানে আমাদের ক্ষেত্রে তো কমার্শিয়ালে ফাইল করেছে, নন কমার্শিয়ালে যেতে চাইছে।
Moreover, my lord, the practice guidelines says about the transfer of a non-commercial suit to a commercial division, not the commercial to non-commercial, my lord. Non-commercial to commercial, but this is a matter of commercial to non-commercial.
We are trying to explore that.
Yes, ma'am.
Commercial থেকে commercial করেছে। That is fine. আমরা কি করে দেবো? What do you say? The bar in clause 4 subrule 2 subclause 2 is to the transfer of
non-commercial
to commercial.
In fact, in otherwise, my lord, in such a case, my lord, Order 7 Rule 10 is applicable. Otherwise, what has held, my lord,
But there is no bar to transferring a suit filed in the commercial division.
my lord, judgment has already.
But why there is no bar?
Said, my lord, Lordship will kindly consider this. In fact, my lord, the very judgment my learned friend is relying upon has held, my lord, the division bench, honorable division bench has held that it cannot be transferred.
It has been
in
transferred.
fact,
This judgment, what has been quoted by the learned single judge?
May I? Lordship will kindly take, my lord, page 103.
Division bench
This is
judgment.
yes, internal page
Division
9 of the division bench judgment that my learned friend is relying upon.
Yes.
That starts with Order 7 Rule 10.
Yes.
Order 7 Rule 10 of CPC provides for return of a plaint where a court is unable to entertain it for want of jurisdiction. It can be territorial, pecuniary, or other causes. If the court is itself satisfied that it has no jurisdiction to try, receive, and decide a cause, it is its duty to suo motu in exercise of the powers under Order 7, Rule 10 to return the plaint to be presented before the appropriate court. Where the court has no jurisdiction over the subject matter of the suit, it has to return the plaint. In such a situation, dismissal of a suit would be unwarranted. Para 18. In the instant case, both the parties have agreed that it is not a commercial dispute. Coming within the purview of 21C of the Commercial Courts Act, the court has also independently come to a finding that it is not a commercial suit. In such a situation, the plaint is required to be returned to the plaintiff to be presented it before the competent court. This power is in exercise of 151 for the ends of justice, and Order 7 Rule 10 is not applicable to the chartered high courts. The plaint shall be deemed to have been filed before a court not having jurisdiction over the subject matter, and the only mode by which a party can continue with the cause is to pray for a return of plaint, so as to enable the plaintiff to present it before the appropriate court. If at any time it appears to the court on the averments made in the plaint itself that it has no jurisdiction, either pecuniary or territorial, or over the subject matter of the court, can suo motu direct return of the plaint. In the instant case, continuation of the suit in commercial division would be before a court without having jurisdiction to decide the suit, as it is to be treated as an ordinary suit. Consequently, a decree passed. I'm not relying upon the rest, my lord. Lordship will thereafter, my lord, kindly take para 20. Next page.
But in this matter also, the return of plaint has happened. Only I am only seeking that the directions given in the judgment may be followed. In this judgment also, it has been said that the plaint will be returned. Kindly let me finish.
Let me complete, then you can proceed.
Every time.
Yes.
Kindly, before the trial court also, please. But only one thing, in this judgment also, my lord,
my lord, address the court.
I'm addressing the court.
No,
not to
you may
interrupt.
not.
I cannot.
Why
You
don't you
were
address each other and allow us to read?
I'm trying to cut short. He's trying to dragging. But here also, return of plaint has happened. I'm not denying it.
On he says once it has to be transferred. Now he says it has to be returned. Both are completely different
Kindly see the
things.
judgment once. I'll raise my case there.
Para 21 in particular. my lord. In fact, my lord, paragraph 20, I'm sorry, my lord. The second part, the learned single judge realizing.
Is what else do you want to say?
Milord, and secondly, Milord, the Honorable High Court has already held that, Milord, there is the court, Milord, does not have any jurisdiction to proceed with the suit. Hence, Milord, the power of transfer may also not be able to, the court will not be able to exercise that power. The only jurisdiction is with return of plaint. Transfer would probably will be when there is a power to exercise a jurisdiction.
But here is no automatic transfer written in the judgment. Here is written the change of nomenclature will happen and I will be able to present. Now to kindly see paragraph 26, on the plaint being represented, the parties shall be at liberty to file additional pleadings if necessary. The pleadings filed in the commercial division can be considered afresh upon the suit being presented before I have to represent it again.
That is the provision of Order 7 Rule 10. He has to again, Milord, the plaint is returned, he has to present it again.
He will not let me place the case uninterrupted.
If you are returning restart from where it was.
Convert করতে গেলেও তো একটা ইনিশিয়াল জুরিসডিকশন থাকতে হবে।
Transfer to them. It is transferred without its antecedents.
না, ও যেটা বলছে কৃষ্ণারাওয়ের কি অ্যাটল কৃষ্ণারাও বললো আমার জুরিসডিকশনই নেই বিকজ দিস ইজ আ নন কমার্শিয়াল ডিস্ট্রিক্ট।
Jurisdiction under section 24 also remains a high court. For example, if before a high court, যেটা আমরা দেখিয়েছিল নাম বলে গেছি judgment but nil paper. What had happened there? The suit was filed in the high court. It was entertained with your hands. It was a suit for land. It was situated in some other court's jurisdiction. Appeal was preferred from an injunction order. It found that yes, it is a before transferring it to that court. In the exercising appellate jurisdiction was the same high court which was bereft of jurisdiction to entertain the plaint in the others. That means
What is section 24?
No, my lord. That is why, my lord, the Honorable High Court has, my lord, held in the, my lord, division bench judgment that it has to be under 151. There are, my lord, certain old judgments, my lord, our High Court judgments of our High Court, my lord, which has held that since it is not applicable Therefore, it can be under inherent powers, it can be transferred. I'm sorry, it can be returned.
We'll transfer under 24, section 24.
May I then consider and come back? Because
will you
this will also have similar effects on many other suits.
Correct,
Because
correct.
may I consider and come back on Monday, my Lordship?
May I say one thing, my lord? May I say one thing?
Consider this case. Take down this case. McNeil Mager versus Mohsin Ali, reported at. It's somewhere 1985. Look it up. McNeil Mager versus Mohsin Ali. Look it up. And any other similar cases if you find.
I didn't catch the name. The
McNeil Mager. McNeil Mager.
McNeil. Yes. I'm familiar with it. I have searched it, but
The division bench holding that this court had no jurisdiction.
Yes.
Because it was a suit for land or something like that. Exercise power under section 24 for transfer.
Very good.
Right?
One more thing, Malad, I have also paid for the interim order that was subsisting at the time of the order. I paid for extension of the interim order, but that was also refused.
Come back on Monday. If we transfer, we'll reinstate the entry for a limited period.
Yes. Upon
the This appeal is directed against a judgment and order dated July 25, 2025, whereby a learned judge of this court has directed return of the plaint of the suit filed by the appellant for being presented before the appropriate court. Stop. Paragraph. The suit was filed in the commercial division. Stop. In fact, however, the dispute involved is not commercial in nature, as is agreed upon by and between the parties. Stop. Paragraph. The plaintiff requested the learned single judge to transfer the suit to the non-commercial division. Stop. The learned judge declined to do so. Stop. Instead, the learned judge directed the plaint to be returned. Stop. Hence this appeal at the instance of the plaintiff. Paragraph. We have heard learned counsel for the parties at some length. Stop. One question arises as to whether or not this court can exercise power under section 24 of the Code of Civil Procedure to direct transfer of the suit from the commercial division to the non-commercial division. So, paragraph. Learned counsel for the parties seek a little time to consider this issue and come back. Monday. Paragraph lists the matter on Monday, date to the other. Once again. Look it up, Mr. Chakravarti.
My lord, I apologize, my lord, for taking so much time. But I earlier told that it would not take time since the appeal scope
No,
is
but
very
this
less.
is an important point.
Yes,
Let us.
Deeply obliged, my lord. Deeply obliged.
My lord, the appeal is against an order by which, my lord, my application for disclosure of additional documents, my lord, were rejected. My lord, against that we have come up in appeal. The defendant did not file the written statement within the specified period and the suit was proceeding as undefended. My lord, under such circumstances, if my lord kindly takes up the impugned order. 60, volume 2.
এইটা কি কাকুলি ঘোষ এটা অ্যাপেলেট সাইড অ্যাপেলেট সাইড
Lord,
Yes, Mr. Mukherjee.
my lord, before Mr. Mukherjee
it
starts, my
applicable?
lord, yes, my lord, the maintainability point, my lord, is a question because I'm covered by, my lord, 4 judgments. My lord,
No, not required. How is this appeal maintainable, Mr. Mukherjee?
My lord, I would humbly submit that the documents which have not been allowed to be disclosed, my lord, if they are not allowed to be disclosed, my lord, my suit goes immediately, my lord.
We don't know about that. How is this order appealable?
My lord, this order I would
Under Section 13 of the Commercial Courts Act, read with Order 43, Rule 1.
my lord, I would rely on, my lord, clause 15 of the latest patent, my lord.
Expressly ousted. Look at
Decided.
Section 13.
Decided.
Expressly ousted, clause 15.
That is, if that be so, my
No,
lord.
Mr. Mukherjee. You're only at a revision.
May I?
No, sorry, SLP. SLP.
May I just show one judgment, my lord, where, my lord, this was passed in a commercial suit itself, my lord. May I just, this was passed on, my lord, 13th of
On
July.
Order 11.
My lord,
Order 11.
Order, my lord, similar case, my lord, where, my lord, documents disclosed were not permitted to be, my lord.
Star paper means, my lord, does not decide the question as to the maintainability, my lord. And in fact, my lord, the same division bench, my lord, has decided the point of maintainability. I'm carrying that judgment as well, my lord.
It's not argued. Maintainability of the appeal is not argued.
My lord, in that case, may I come back on some other day, my lord? One
Everybody
more
will come
opportunity,
back.
my lord, gives if something, if I'm able to find out, my lord.
Come
My lord,
back on Monday.
I'll come back on Monday.
This appeal is directed against a judgment and order dated September 17, 2024, whereby, in a commercial suit, the learned single judge dismissed the plaintiff's application for disclosure of additional documents. Stop. Paragraph. Learned advocate for the respondent bank says that this appeal is not maintainable on a reading of Section 13 of the Commercial Courts Act, 2015, read with Order 43, Rule 1 of the Code of Civil Procedure. So, paragraph. Learned counsel for the appellants seeks a little time to consider this issue and come back on Monday when this matter will be listed again.
Grateful to my lord. Grateful.
My lord, appearing on behalf of the petitioner, my lord, praying for a short passover, my lord, Mr. Banerjee is engaged in some.
Yes, yes, Passover, Passover.
Much obliged.
Passover for the day or Passover?
No, my lord, Mr. Banerjee is engaged in some other court. He'll be coming, my lord.
Will come.
Yes.
Very well, Passover.
Much obliged.
Yes. Gold tag and gold flake.
My lord, prior to your lordships, my lord, before going even into the order, I think your lordships need to see this act first.
I'm appearing for the respondent number 1, your lordship. I'm the plaintiff in this matter, and I'm led by Mr. Mr. S.N. Mukherjee, Mr. Ranjan Bashawat, and Mr. Ratnango Banerjee.
Very well.
Your lordship takes, my lord, in সমাজের মধ্যে একটা hand over, my lord, this act, because this was completely missed out, my lord. At least I don't see any reflection of this, my lord, in the order or in the submissions or anywhere. My lord, this becomes very important because what we are dealing with is cigarettes. And my lord, the trade, my lord, the selling of cigarettes, advertising of cigarettes, everything is regulated by this act. In fact, it says how the packet will look, what will be the depiction of pictures,
what percentage,
everything. My lord, this sum, because my lord, I'll show the impugned order. An impression has been given by taking that picture of 85%, which is there on both the packets, to show that it has been copied. So my lord, kindly takes first. My lord, it's first of all, my lord, an action. My lord, it's a rolled up action. Copyright infringement, trademark infringement, and passing off. My lord, their admitted cases, they say passing off is outside jurisdiction, and the other two are within jurisdiction, and therefore they've prayed for clause 14. Well, it's something which would go to the very root of the matter is clause 14 leave is not granted till date. But an order has been passed.
Clause 14.
Yes, my lord.
Hey, original side rules.
The original side rules, clause 14. In fact, my lord, initially when the ad interim order was granted, the court, being conscious, did not pass any prayer for passing off. My lord, I am also covered by a division bench judgment of this honorable court. My lord, I'll cite that. That first, my lord, a clause 14 leave is required.
Single bench or all orders are compilation.
My lord, these are all the orders passed by the honorable trial court. My lord, your lordship will not find, my lord, any order granting leave under clause 14.
Now,
Yes.
now.
Yes, সব দেব। There was the show cause issued, my lord. But thereafter, my lord, that leave was never granted. That was kept the way it was, my lord. And my lord, this issue, my lord, also came up before this honorable High Court, 2016, SCC Online Calcutta 1151. সব একসঙ্গে করেছি? আচ্ছা, করেছি। দাও। আমাকেও একটা কপি দাও, কিভাবে করেছে। সব দিয়ে
Serial number 3, page 7 to 12. Hindustan Leave, 3 leaves.
Now,
So show cause was issued.
yes, but thereafter, my lord, it was lost.
Did they file a response?
No, my lord, we were there, my lord, we are the, my lord,
Sorry, you.
respondents. No response file, but matter proceeded, heard, but at the end of the day, my lord, today, there is no leave under clause 14. And without a clause 14 leave, my lord,
There's no.
could not have been done. And my lord, now, my lord, if your lordship now kindly takes first, my lord, I'll before going into the, my lord, law, my lord, this act, my lord, will be of great significance to this entire appeal. If your lordship takes this act, this came in 2003, my lord. No, দিয়ে দিয়েছি। চারটে আছে। Now, if your lordship sees, my lord, section 5. There's a prohibition even of advertisement of cigarettes and other tobacco products. Now, my lord, also takes after section 5, my lord, there is also even restrictions, several other completely regulated. This is an industry which is completely regulated. My lord, section 8, manner in which specified warning shall be made. In fact, what language it will be, how it will be, everything covered under this act.
Those are provided in the rules. The
That I
details.
show, my lord. Also, my lord, the schedule right at the end, my lord, cigarettes is the first product. We are dealing with cigarettes. Just, my lord, for completeness. Your lordship has the schedule, right?
Yes.
Cigarettes is the first product. This is what we are dealing with. Now, if your lordship sees in that same book, my lord, there is cigarettes and other tobacco products packaging and labeling rule 2008. Now, if your lordship kindly, my lord, takes, my lord, rule 3, manner of packing and labeling.
Yes.
Every person engaged directly or indirectly in the production, supply, import, or distribution of cigarette or any other tobacco product shall ensure that every package of a cigarette or any tobacco product shall have the specified health warning exactly as specified in the schedule to these rules. Now kindly see 2B. The specified health warning shall cover at least 85% of the principal display area of the package, of which 60% shall cover pictorial health warning and 25% shall cover textual health warning and shall be positioned on the top edge of the package and in the same direction as the information of the principal display area. Then if your lordship sees, my lord, everything is given, how it will be. Now, my lord, kindly see E. 3E is extremely important. No product shall be sold unless the package contains the specified health warning. Because, my lord, I see, my lord, in the pleadings, a case has been made out. What about loose cigarettes which is being sold? My lord, under this act, perhaps, my lord, I don't think, my lord, a person can sell loose cigarettes. Because it has to be sold in a pack.
Oh, so all these pawn shops and all this.
It's all, my lord, they are not, my lord, authorized. My lord, a lot of places, my lord, a lot of clubs, etc., my lord, they don't sell loose cigarettes. That's why. Because they don't want to fall foul of the law.
No club.
Your lordship will see clubs, 5 stars, a lot of other places, they only sell packets. So, my lord, this is how it is, my lord. My lord, 3E, if your lordship has seen. No product shall be sold. So unless the package contains, which necessarily implies it has to be through in a package. Now, another thing which may be significant, my lord, 3G. No tobacco product, package, or label shall contain any information that is false, misleading, or deceptive that is likely or intended to create or erroneous impression about the characteristics, health effects, or health or other hazards of the tobacco product or its emission. This prohibition includes, but is not limited to, use of the word descriptors, whether or not light, ultralight, mild, ultra-mild, low tar, slim, safer, these have all been done away with. This becomes significant because the industry, my lord, thereafter shifts to colors to indicate, my lord, the strength of the cigarette. Once this has been
There
done.
used to be classic lights. Light is gone now. I see.
So, my lord, the color code comes into play.
Yes, Benson is blue. Yes.
Just since we have my lord few minutes today, but these cigarettes are not sold in 5 states. Or in
We are sold in Punjab.
And my lord, it's recognized, my lord, judicially, my lord, of my lord, those my lord cigarettes being sold in passing of actions.
We'll address, my lord, whether passing of case at all, my learned friend can run without the clause 14 leave or not. So, my lord, kindly see thereafter, my lord, 4. Prohibition, my lord, no person shall sell or supply any product, device, or other things that is intended to be used, can be used to cover, obscure, mask, alter, or otherwise detract from the specified health warning. So, health warning has to be there.
Yes.
And, my lord, how it will be rotation of specified health warning. Now, if your lordship takes the page right next to it, images are given. Well, these images I'll show from the impugned order were shown to the learned trial court to show, look, they've copied my packaging. Well, they should not have given this, my lord, as a comparative, in the comparative chart to show.
You said it's a statutory requirement.
So, my lord, your lordship will not find any discussion with regard to this act or, my lord, the rules framed thereunder in the impugned order. Now, if your lordship takes, my lord, the first point, my lord, I said it's a rolled up action, my lord. There are certain jurisdictional issues, my lord, which your lordship perhaps would have to address, my lord, which would go to the very root of this case, my lord. First being, my lord, clause 14 leave not having been granted, passing of order would automatically go. My lord, for that, my lord, I'm relying on 2016 SCC Online Calcutta 11151. My lord, it's in the compilation.
Serial number 3, page 7.
Serial number 3, page 7 to 12. Other side के लिए दिया था ऊपर में. दिया था उन्हें.
Thank you.
The serial number 3, page 7 to 12. My lords, here also it was moved ex parte. First,
One second. কে করেছে এই ভুলটা? তুমি তো নিজে করোনি, যে করেছো Atleast বলো যে কেন এই ভুলটা। তুমি যদি না বলো তাহলে সে আবার এই ভুলটা করবে।
Or first, my lord. The 4, after my lord 4-5 lines, it is not possible for the court to ascertain, in the absence of the plaintiff, whether any leave under clause 12 of the letters patent was sought or the leave under clause 14 has been granted by the court. My lord, then, if your lordship comes to, my lord, the same paragraph, my lord, if your lordship turns over to the next page, it will be internal page of the judgment. Right at the top, there is no difficulty in combining several causes of action.
Yes.
In one suit, in the original side of the High Court, provided a leave under clause 14 of the letters patent is first obtained. Well, in this case, that leave is still not there. In course of the hearing, the plaintiff was requisitioned from the department, and it appears that neither leave under clause 12 of the letters patent nor under clause 14 is sought or granted. My lord, in our case, not granted. Clause 14. And my lord, ultimately, my lord, it was not entertained. My lord, an appeal was carried from this, not interfered with. My lord, certain observations were made, my lord, against which, my lord, an appeal was preferred. July 20, 2016. DD order. Now, na compilation हमारी देखते तो हिंदी में ना पढ़ो.
Join the action easy to the position. No. The channel was looking at the outside jurisdiction. This
This was carried on appeal, my lord. I don't, my lord, my learned junior has missed out this copy in the compilation. My lord, we'll hand over a copy. My lord, your lordship takes it, my lord. It was not interfered with. Only, my lord, the comments with regarding to the advocates, etc., was expunged, and the suit was withdrawn also. In the Justice Indira Banerjee. Now, my lords, having, if this being the position, my lord, passing of goals, my lord, without even going into the merits. Now, the second issue, my lord, is, my lord, trademark infringement. The second cause of action. My lord, trademark, my lord, infringement, my lord, on the face of it will not lie, because both are registered.
both are registered.
Both are registered. And the trial court also, my lord, did not grant injunction. My lord, modified the injunction because it said that so far as this issue is concerned, we'll decide at the stage of trial. I'll show it from the impugned order. But now this position is well settled. I'll cite, my lord.
Your gold stag is registered.
My lord. It's IMG gold stag we have. Now, my lord, this issue, my lord, with regard to, my lord, whether one registered.
And the case pleaded in the plaintiff is that passing off is entirely outside jurisdiction.
Yes. My lord, that is why clause 14. Otherwise, they wouldn't have required clause 14. And my lord, the trial court being conscious of the fact, when they moved it ex parte on 6th of February 2025, did not grant any prayer for passing off. I'll show from the prayers which were granted. Now, my lords, so far as infringement is concerned, my lord, your lordship sees first the Supreme Court, 2016 2 SCC 683, my lord. It's there in the.
Doesn't the Act say so?
My lord, Act section 28.3, my lord, that has been interpreted by the Supreme Court.
Yes.
My lord, I'll show first 28.3. Your lordship is absolutely correct. But kindly take section 28(3) of the Trademarks Act. But they
Trademark.
knew all this. It is not that they were not aware of it. Let's kindly see section 28, rights conferred by registration, and 28(3). Whether two or more persons are registered proprietors of trademarks which are identical with or nearly resemble each other, the exclusive right to the use of any of those trademarks shall not, except so far as their respective rights are subject to any conditions and limitations entered on the register. Your Lordship will also note this, because this will also come into play, because I will show before the trademark registry, they've made a representation, at least 6 of them, that they are not claiming any right over the word gold. Gold is disclaimed. And what would be the effect of that in law and in view of the recent Supreme Court judgment, my lord, in the Blender's Pride case, my lord, that also I will cite. Be deemed to have been acquired by any one of those persons as against any other of those persons merely by registration of the trademarks, but each of those persons has otherwise the same rights as against the other persons. So, my lord, this has been interpreted by the Honorable Supreme Court, saying one registered owner cannot sue another registered owner for passing off, for infringement.
Serial number 17.
Now, आगे मैं Delhi High Court था recent August 7, 2025. Now, my lords, even after the Supreme Court judgment,
Yes.
now, my lords, even after the Supreme Court judgment of 2016, there was some confusion created in the Delhi High Court whether one registered owner could actually sue another registered owner. My lord, this happened, but my lord, subsequently, my lord, one of the honorable judges who was presiding over the division bench, when a subsequent matter came up, my lord, as recent as on, my lord, August 7, 2025, took note of the Supreme Court judgment and answered this issue.
Which is that Supreme Court? You haven't said.
The Supreme Court, I will, my lord, it's in the compilation. I'll first, my lord, show the Delhi High Court, my lord, because
serial number 20.
What the honorable trial judge has done is, my lord, relied on a single bench judgment saying that it cannot be ruled out.
Serial number 22, page.
But kindly see serial number 22 first.
Page 498 to 518.
Serial number 22, page 498.
He leaves the division bench till that. So, well, let's kindly see this, because this actually, my lord, frames the question and answers it. Lordship has got 498.
Yes.
It should see the prefatory note first. No infringement action can lie against a registered trade.
Yes.
And my lord, then, my lord, it mentions about the other 2 division benches. And now, my lord, if your lordship sees paragraph 2, Rajkumar Prasad has been followed by another division bench of this court in Corza International versus Future Bath Products Private Limited. We have not come across any other judgment of any division bench of this court or of the Supreme Court which holds that an action for infringement can be instituted against a registered trademark. However, post Rajkumar Prasad, some single benches of this court have following it entertained infringement actions against registered trademarks and even injuncted their use. At the same time, there are other judgments also of learned single judges which have, albeit without noticing, Rajkumar Prasad held no infringement action can lie against a registered trademark. Then, my lord, a coordinate division bench, my lord. Now, my lord, here it comes. A coordinate division bench of this court, through an opinion rendered by one of us, has in Ports International Private Limited versus Ashish Bansal doubted the correctness of the view expressed by Rajkumar Prasad and has therefore referred the issue to a larger bench. The outcome of the reference is still awaited. Now, if your lordship turns over. Now, my lords, kindly takes paragraph 5. We have post abroad studied the legal position further and find that the view expressed in Rajkumar Prasad that an infringement suit lies against the proprietor of a registered trademark and the use of such registered trademark can be injuncted following a finding of infringement is contrary to the law declared by the Supreme Court. Albeit later in point of time in Syed Moinuddin versus P. Sulochana Bai, which clearly holds that no infringement action can lie against a registered trademark. Rajkumar Prasad has therefore no longer be regarded as good law. Now, if your lordship takes Sulochana Bai is also in my compilation.
Serial number 17, page 295 to 315.
Well, let's kindly take serial number 17.
Page?
Well, the page 295 of the compilation. No.
Yes.
No. Now, my lords, if your lordship takes 295 at my lords, paragraph 28 onwards, my lord, 233, my lord, the entire discussion is there. My lord, this judgment basically comes to the finding that, my lord, one registered proprietor cannot sue another registered proprietor for infringement. Can sue for passing off, but not for infringement. Well, that's the statute also.
Yes.
But my lord, still, my lord, because my lord, there was some kind of, my lord, I'll show from the impugned order what has been stated. And apropos that, my lord, I cited the Delhi High Court judgment, which also recently considered this entire thing. And my lord, this is, my lord, what transpired in the Delhi High Court. Now, my lord, the division bench, my lord, which my lord, my learned friend didn't have a copy, my lord, is here. This was the appeal from Justice Tandon's order before the division bench.
So,
14 leave आगे यदि ना है ना এটা আগে দেখিয়ে ছিল এটা কপি ছিল না But in fact, in the appeal, they said they would withdraw the suit. And my lord, only with regard to the observation, nothing with regard to clause 14. So, my lord, the clause 14 point remains. Kindly sees, my lord, internal page 3. The submission is Mr. Such and such on instructions that the suit being CS number 130 of 2016 shall be withdrawn.
yes.
This was the appeal order, my lord. So, my lord, without first obtaining, my lord, they could not have gone for passing off. My lord, now, my lord, so far as infringement concerned, my lord, that is also, my lord, clearly statutorily. Only thing left with copyright is concerned. My lord, these are all the preliminary objections without even going into the merits. My lord, copyright, my lord, they have disclosed several, my lord, certificates saying that it's an artistic work. What they don't do is, my lord, they have not complied with section 45(1) of the Copyright Act, which is mandatory. My lord, if a particular trademark is also being registered as a copyright, my lord, a certificate is required, my lord, from the registrar of copyright.
Yes.
From the registrar of trademarks, my lord, which requires to be furnished. My lord, kindly take section 45(1) and then I will show that this has been held to be mandatory. In fact, my lord, my copyright registration, my lord, has been discarded by the learned single judge on this ground.
Mr. Prashidri, we have fixed, we have a different bench at 12:45. 12:40, Mr. Joydeep Kaur's matter will come back on Monday.
very well.
Same position.
The only thing is Monday, then it'll happen only on Friday because Monday, I believe after 12, there won't be any
What?
court. Well, Vodafone is there.
Voice.
Yes,
And also GECL is also there.
উনি কোথায় এখন?
Banerjee is there.
কোন দেশে উনি?
No, my lord, I'm very much here.
লেখো।
Well, let it written in.
Yes, yes. Mr. Shomo Rai Choudhury, Learned Counsel, appearing for the appellant, begins his argument but does not conclude. Paragraph. Let them.
I'm being led by Mr.
Oh, sorry. Mr. Shomo Rai Choudhury, Learned Counsel, led by Mr. Tilak Kumar Bose, Learned Senior Counsel, begins his argument but does not.
We have started the argument.
Oh, started. Resumes.
I had
Resumes his argument but does not conclude. Paragraph. List the matter. Let the matter retain its position in the list.
This notice of motion, my lord, those affidavits, my lord, I'm just filing it on record.
File it. ঠিক আছে? Let the matter retain its position in the list. उदा फोन चालाक फोन की जाता है
That's also an interesting.
Yes, yes, you had started. Yes.
Under the old act.
Yes, yes.
And your lordship's remark, my lord, that I should not be generating gas.
That one left to me.
এই দেখো জয়দীপদের মামলাটা দেখো। Could you catch hold of somebody on your other side?
I'm there for this.
We'll just extend by 7 days.
No, kindly, my lord, extend it till 22nd, my lord, of September,
Very well.
which is the Monday.
Monday. Order to the.
Yes. Give you 2 copies. আরেকটা কপি আছে এই এটা আরেকটা
Changes to be that one. That within 22nd.
Third, Learned Counsel for the parties. Paragraph. The time to furnish bank guarantee in terms of our order dated August 29, 2025, is extended till September 22, 2025.
But the unconditional stay should also be.
Stop. The order of unconditional stay of the concerned award shall continue till September 25, 2025. Stop. If in the meantime the bank guarantee is furnished, the order of stay shall continue till the disposal of the appeal.
Much okay.
উঠি আমরা
Number 1 and 2.
Yes, my lord, I am for the petitioner.
First time. First time.
No, my lord.
Affidavits have been exchanged.
You are appearing.
Yes. I am being led by my lord, the learned Advocate General.
Does it
Lord,
matter?
He will be coming.
Reply, my lord.
No, file your.
No, I have already.
You have filed your opposition.
Opposition has been filed.
This is
Today is
my
the
reply.
date for.
Have you given them copy?
Yes.
Yes. Served.
Oh, so this has to be heard now.
Yes, my lord.
Lord, there is
And
also.
second matter, who is in the second matter?
I am in the second matter.
Sorry, the third matter. I mean, Shuhashini Lohia.
That is incorrect.
That is
I know.
incorrect.
It's your matter. First time.
No, it has appeared in the past.
Hmm.
Your lordship. has-
Affidavits have been filed.
No, your lordship hadn't directed affidavits, but there has been some development that in this matter.
Why? We'll pass this over. We'll pass this over because this will take time. This is a hearing matter.
However,
Mine should not take very long.
your lordship may also consider, we were going to make this submission before your lordships.
Yes.
As far as there is the memorandum of review also, at item number 2,
yes,
for review of the judgment and order of which my lord contempt is
Yes.
alleged. Now, my lord, after this matter, this order was passed, there was another litigation by a series of employees of the same board, where similar matters were my lord questioned, my lord, before the honorable single judge. The Labour Welfare Board, my lord, suffered an order from there. An appeal is pending. It was listed today before the honorable division bench, my lord, presided over by Honorable Justice Sujoy Paul. And in that, my lord, extensive pleadings have been filed, and it has been kept after vacation today only for my lord final hearing. So, my lord, your lordships may kindly consider whether, my lord, there will be a possible chance of divergent view or not if both these are, my lord.
For the time being, let us pass this over and take up that matter.
Very well.
Or let us keep it out immediately after the vacation.
My lord, that matter, that is my learned
Not
friend
because
is
of that.
concerned.
Not because of that, madam. Hearing matter. It will take a little time.
Yes.
My lord.
So starting today, before vacation, we will not be able to assemble again.
Yes, my lord. Yes.
So we'll take your reply on record today and keep it immediately after the vacation. And then let us see. If there's a chance of divergence, then we'll pass appropriate orders. But we'll consider it on the next date.
I just wanted to submit, my lord, that matter is for considering the 6th pay commission. And this matter is one, this is a long pending matter. Single
Just
bench judgment passed, division bench judgment has passed. This is for commutation of pension, my lord.
Issues are
Only
same.
one
Whether
petitioner,
DCRB rule applies or
commutation of
not.
pension.
Very well.
Commutation of pension, my lord. Nothing more, nothing less.
We'll take it up immediately after the affidavit in reply filed on behalf of the petitioner by the petitioner in the contempt application be kept with the records. Paragraph. Learned counsel for the parties say that hearing of this matter shall take a little time. Stop. Today there is not much time left. Stop. The puja vacations are knocking on the doors. Stop. Paragraph. List this matter. List these matters. Koro. Review to ache to ekta dui ekshonge koro. List these matters immediately after the puja vacation, whenever this bench is again available. Hey, এটা bench মনে করে করে দিও.
সেটাই ভালো হবে। এটা অনেক সময় লাগবে।
I will mention, my lord.
You can tell our
Yes.
court officers.
Yes.
They will constitute a bench.
He's 74-year-old petitioner, my lord. He's present in the court. He's a patient of heart, my lord. He needs money. His only money he's praying for, my lord. Grateful.
Gratefully, lordships.
Item number 3.
I appear for the applicant. I'll begin with a caveat. I may ultimately have to withdraw this application. I'll tell your lordship why. My lord, contempt preferred against the corporation authorities for non-compliance of the appellate court's order. Writ application, initially, my lord, writ court passed an order directing the corporation to take steps under 412 capital A, which is to, my lord, conduct a hearing, give an opportunity to the owners, the occupants, condemned building. Now, my lord, this is, my lord, the building is almost 100 years old, situated on CR Avenue. The metro rail has gone just beneath it. It has developed a vertical crack of almost 1.5 feet. And this is not the petitioner saying it, it is the writ court had appointed Jadavpur University Construction Department. Independently, they also conducted an assessment, they have confirmed these findings. Thereafter, the private respondents, the occupants, they preferred an appeal. Your Lordships, confirmed the single bench's order, but extended the time by which the corporation was to complete this exercise. Now, when we filed this application, we did not know about any order passed by the corporation. We had participated in a hearing, but thereafter we had heard nothing from the corporation. We had written several letters, no response. Now, after this matter had appeared early in 2025, when corporation was also represented, even they perhaps had no instructions. Your Lordship granted leave to carry out certain amendments. All of that has been done. Thereafter, in about April or May, we come to learn that such an order has been passed. The order, again confirms that it is in fact a condemned building. It is very dangerous, not only for the inmates, also for passers-by. And the occupants were directed to vacate within 30 days so that it could be demolished and a fresh building, new building.
Directed by KMC.
By KMC, that is the order. Now, they have not vacated within 30 days. Not only that, in order to prepare and submit a plan, because the corporation order requires me to submit a plan for reconstruction, for demolition and reconstruction. But I need, because there are so many occupants, and your Lordship's order categorically stated that after reconstruction, the occupants will have to be rehabilitated. Now, in order to do so, under the building rules, I have to furnish a list of the occupants, the area that is under their occupation, so that floor area ratio and so on and so forth can be determined. Now, I'm in such a predicament today, even though there is an order of the corporation, it is not being implemented. Because the private respondents are putting a spanner in the works. So I might have to take out a fresh contempt application.
Yes.
Against
Nothing
these.
remains in this.
Nothing in this.
Nothing remains. Here is my report, my lord.
There is an order.
The order was passed. Everybody, we heard everybody. And order was passed. And in the order specifically, there is instruction for submit a proposed plan. My lord, your
Mr.
lordship.
Gopal Chandra Das.
Lordship, your lordship.
Right order or wrong order? Whatever you pass.
My lord, that is the 412 capital A. My lord, there we, my lord,
Anyway, they have complied with our orders.
Okay, that is that.
Sure. Learned advocate for the.
Only, it may not be necessary, but liberty, if any, may be reserved to me that any fresh non-compliance or breach or by the private respondents that may be kept open. So that I'm not precluded by reason of this order from coming afresh with a contempt application.
The petitioner had approached a learned judge of this court by filing a writ petition complaining that in spite of having made representation to the KMC authorities, no steps were being taken in respect of a dilapidated building on Chittoranjan Avenue, Kolkata, which is in a dangerous condition, posing threat to the occupants thereof, as also the nearby residents. Stop. The learned judge disposed of the writ petition by directing KMC. Please correct me because I'm
extempore
dictating entirely from memory and what it should be. That's what I'm saying.
May I hand over a copy of your
No,
lordship's
no,
order?
no. Just correct me if I am wrong. Directing the KMC authorities to initiate proceedings under section 4412 capital A of the KMC Act, 1980 and take appropriate action. Stop. Paragraph. The said order was carried in appeal before us by some of the occupants, of the concerned building. Stop. By our judgment and order dated December 18, 2023, we had disposed of the appeal being APO 190 of 2023 by affirming the order of the learned single judge and by extending the time for KMC to carry out the order by 4 months. For KMC to carry out the order by 4 months.
There was also one clarification. I'll just read out. We, however, clarify that in the event, I'll read the entire paragraph. Accordingly, we do not interfere with the order under appeal. We, however, clarify that in the event the building is demolished and reconstructed, the appellants will be rehabilitated therein in accordance with law.
We had also added that in the event the building was found to be a condemned one and therefore had to be demolished, comma, the occupants thereof would be rehabilitated in the newly reconstructed building. Stop. Paragraph. Alleging violation of the aforesaid judgment and order dated December 18, 2023, the present contempt application has been filed. Paragraph. Learned advocate for the, you are appearing for whom? KMC. Learned advocate for the respondents. File, what are you filing?
That is my
The files a compliance report within court debe. Compliance report dated March 3, 2025. Stop. It appears from such report that the proceedings under 412 capital A of the KMC Act culminated in the KMC's decision that the building in question indeed requires to be demolished. Stop. Appropriate notice was issued by KMC to the occupants of the building for vacating the same. Stop. Paragraph. Therefore, we find that although belatedly, the order of the learned single judge as affirmed by us, has been implemented by, has been complied with by KMC. Stop. Paragraph. Learned Mr. Mukherjee, learned advocate for the petitioner, says that the predicament that the petitioner is the owner.
Yes, my lord.
Predicament that the petitioner is facing is that the occupants of the building in question are refusing to vacate the same. Stop. Therefore, the building cannot be demolished. Stop. Stop. Paragraph. We put such submission of Mr. Mukherjee on record. Stop. However, we cannot pass any direction in that regard in this contempt application. Stop. We
only me.
our key.
My lord, page 6, my lord, if your lordship kindly. Because
What
that
we are disposing of. Yes. Paragraph. The present contempt proceedings stand closed. Stop. CC 73 of 2024 is disposed of. Paragraph. This will not prevent the petitioner from initiating appropriate legal proceedings, including contempt proceedings, if he is entitled to do so in law. In law, before the appropriate forum.
My learned advocate on record correctly points out, not only are the occupants refusing to vacate, but they are also not allowing us access to measure so that we can submit, because that is the requirement under.
Please just put it on record.
If your lordship considers it.
যেখানে বললাম refusing to vacate বলেছি, হ্যাঁ, ঠিক আছে, ওইখানটা add করো. It is also submitted that the occupants are refusing access to the petitioner or his agents to carry out requisite measurements as is required under section
142 of the Kolkata Municipal Building Rules.
Rule 142.
Rule 142. I'm sorry.
Under Rule 142 of the KMC Building Rules 1980. 2009. Correct. Sure.
Very good.
Seeing you after a long time. All well?
Trying to remain as sweet as possible.
ঠিক আছে আমরা
I am active in the court every day.
হ্যাঁ ও অ্যাপিলেট সাইড আছে ওরে বাবা
I'm deeply obliged.
কটা আছে দাও দাও চট করে দাও হ্যাঁ ডিসপোজ দাও হ্যাঁ আরে হ্যাঁ হ্যাঁ ভেঙে পড়বে যেদিন বুঝবে কি করা যাবে উত্তর
Item number 1. But I appear on behalf of the petitioner. Now, this is the first time appearing before my lord.
Which is the order?
Order page 18, not 14th of March 2024. Violation part is relevant portion, page 24. Third paragraph. 24th, third paragraph, my lord. Third, my lord, fourth paragraph.
Hey, Yeshu, serve.
Yes. Notice has no, the notice, brother. This is the new one thing. Two things are there. Now, this order has been served upon them. They have not taken any steps. We again issued a contempt notice. Even then, they have not taken any steps.
Serve copy of this contempt petition.
No, this is the first time appearing.
We are directing you to serve.
Yes. Yes, but one thing is more, my lord. My lord, new incumbent has joined the office. So kindly grant us leave to add the new.
Which office? Post of?
Post of case. Executive engineer, my lord. My lord, contempt number. No, the contempt number 1 has been changed.
Paragraph. Learned leave is granted to the petitioner to add the new incumbent in the post of executive engineer, National Highway Division -1, PW, P stop W stop bracket roads, bracket closed, directorate. Hey, cost title থেকে দেখে নিও, as the respondent number 3, as the alleged contemptor number 3 in the contempt petition. Stop. Give the name. Acha, you know the name. You may learned advocate. No, that your advocate on record will do it.
Yes.
Learned advocate on record for the petitioner shall make necessary amendment in the cause title of the contempt petition. Stop. Paragraph. This contempt application has been filed alleging willful violation of a judgment and order dated March 14, 2024, whereby we had disposed of MAT 451/2024. Stop. The operative portion of the said order reads as follows. Page 24 of the contempt petition, marked bracketed portion, 24 or 25.
We are the appellant. I am the appellant in this matter. We have not served a copy.
You are not a party.
You are not a party.
Not necessary. Paragraph. Learned advocate for the petitioner says that in spite of due communication of the said order to the alleged contemptor, followed up by a contempt notice, no action has been taken to implement the aforesaid order. Paragraph. Let service of this contempt petition be effected on the alleged contemptor numbers 2 and 3, assistant engineer and the new executive engineer, 2 and 3, and affidavit of service be filed in court on the next date. Paragraph. List this matter once again after the puja vacation, whenever this bench is again available.
Grateful to judge.
এই প্রেজেন্টেশনটা ভুল ছিল বলছেন, পেজ 24 না কত বললাম? আমারটা 24, এটা 23, 24 দেখেন। হ্যাঁ,
strict.
Well, in a matter, my lord, item number 18, well, when the matter is going on in the list for a long time, today is the 18, without any notice, the entire demolition work has been done. Without any notice, these are very poor person during this monsoon season. Again, they have, my lord, attacked on my place, the Municipal Corporation, without any notice, ignoring the fact the matter is, what is season of the matter, ignoring the fact. And the police has assisted. I do not know, my lord, what is going on there. But kindly, my lord, before rising, my humble request is that this item number 18 must be called up. One application I have made long back that is not disposed of, entire thing has been demolished. And law is taken up in their own hand by the authority itself.
Let us see.
My lord, kindly, my lord. Gratefully.
Item 1 to 4.
Item number 1 to 4.
We really wanted to agree to ball.
Yes, we have heard the matter long back. Kindly refresh our memory. And we are basically were very keen on hearing the state because a different stand has been taken by the different.
In the notes, yes.
The final stand, that is the why we have bit confused also that proceed on the basis of what.
Even, my lord, on the last occasion, your lordships were pleased to make it very clear that, my lord, they should be here, my lord, to.
So kindly just.
Well, I shall give a very, my lord.
In a very short, what is the gist of your argument? Then we'll hear the state and.
Maybe while you are submitting, the state will come, or your juniors advocate can try to contact somebody.
In brief, Mr.
Yes,
Mr. Kindly tell us what is the matter about and what are the points involved and what is the proposition of law.
My lord, I will tell you, lordships, very briefly. My lord, it's a large chunk of land. A large chunk of land, my lord. A part of it was originally, my lord, acquired, requisition, then acquisition. Then another part, my lord, requisition, acquisition.
So there is a one stage before. It was acquired under the Estate Acquisition Act. You filed a B form. What was the retained parts? Kindly start from that. Because the story starts from that only.
There was no retention because, my lord,
First, when the 54, under the 54 Act, some portion was retained. What was the character of the land described? Karkhana or Vastu or what? That is the first point.
My lord, for retention, my lord, the earlier part, the government had to, my lord, give the, my lord, the notification. That was never done. That was, my lord.
No, that was done. Secondly, when the another requisition under section 6 notification, that was never done. But at the inception.
Resumption.
At the inception.
Inception কোথায় ছিল? Stop rates টা
HON'BLE retained. Retention by filing B form. The story starts from that point only.
HON'BLE was the lessee. Yeah. Stop this. Stop this.
List of history.
নোট আছে তার মধ্যে লিস্ট অফ বেস্ট দেওয়া আছে।
হ্যাঁ, জানি। My lord, kindly take my notes, my lord, the notes which was submitted, my lord. The first notes.
Yes.
Lordship's got that, my lord.
Yes, can you see the 1995 date? 15th April 1995.
প্রথম নোটসটা
Operating factory in the premises before vesting of 1995. So these vesting order, we want to see that what was the law, what is the land retained? As Karkhana or as Vastu?
এটা নিন কোথা থেকে পড়লেন? টেস্টিংটা কোথায়? স্টেটের নোটটা করে বলছি।
Well, let kindly
List of dates, are you on the list of dates? 15th April 1955. Such land had been vested with the state by operation of. This vesting order is the starting point.
kindly take up my notes, my lord. There was এর আগে যেটা করলো এগ্রি করলো প্রতীকে এসে কোর্টে there was no order of vesting.
সেটা ডিজাম্পশন যেটা এসে এর কাছে বলে গেল ডিভিশন বেঞ্চে অর্ডার
সেটাই রেসিডেন্টের ব্যাপার ছিল।
No notice of resumption was ever given.
Kindly take my notes.
So the whole idea is to ascertain that the nature of land that was retained after the Estate Acquisition Act, what was the land was, how the land was characterized. Right?
Well,
In the order of the tribunal mentions. Order of the tribunal that you have successfully challenged.
Yes.
That order mentions. Tribunal file
paper book first. Oh, the land tribunal order. Page 46.
47.
Yes, kindly come to my lord.
Page 46.
Mat 509. Page 46, 47. 46. But kindly take the order, my lord, of the tribunal. Page 46 of my lord, volume 1, in mat number 509.
This is the kindly see, second paragraph, the finding of the tribunal. Second paragraph.
Yes.
Kindly read it. The following.
The following submission has been advanced on behalf of the applicants. Bhagyalakshmi was a lessee in respect of 27 bighas of land comprised in premises number 5/5 BT Road, Vastu land, Pukur, Danga, etc. It was not land comprised in factory or workshop. In the record of right revised under the West Bengal Estate Acquisition Act, the said company retained all the land as a non-agricultural tenant directly under the state government under section 61C.
This retention, we have to see what is the character of the land. Need to start. The story should start from this one. That retained all the land as a non-agricultural tenancy.
এটা দেখো পর্চাটা পড়ে দেখো
Factory was not there.
Yes.
Then
you have that reform by which this lands were retained.
No, it was not, my lord. It was not part of the record, and I will tell you, lordship.
Kindly find out whether there are no.
Wait.
But the controversy rests upon these also.
Only one thing, my lord. If your lordships are pleased to come to my lord. এই অর্ডারটা কোথায় বলো যেটাতে ডিভিশন বেঞ্চে এসে বললো
because this was the stand of the your stand before the tribunal that this was never treated as a karkhana, this was a non-agricultural tenancy. This is how the land was retained. If that be the case, then subsequent resumption under section 8 treating it to as a karkhana doesn't arise.
My lord, it would appear from the porcha, my lord. I can. Oh, very well. Kindly come to my lord. FMA 92. Kindly come. 66.
Which item, Mr. Basu?
Next bunch. 5.
Oh, the corporation bunch.
মানে 5 to 2. নাকি নিয়ে আমরা ডাবল কাছে যশোর জিজ্ঞেস করলো আনসার কলেজের
Is signed.
State Acquisition Act is
Hmm.
Kindly come to page 66
So there, page 66, yes.
of my lord MAT, my lord FMA 92 or MAT 207.
And kindly show us, because we want to compare the land that has been sought to be resumed under section 6, that schedule of that land with this land. We just want to see whether this land was the subject matter of the resumption.
Kindly once, my lord, sorry, my lord, I possibly am not assisting your lordships properly. Kindly once come to MAT 509 and an order of a previous division bench. 509, page 56.
This order.
No.
Previous division bench. In which matter?
My lord, this my lord stand was taken, my lord, was challenged before the my lord land LRTT. From that, my lord, the state had preferred an appeal. LRTT's order.
Yes.
Now kindly come to that order.
Yes.
Page 56 of my lord MAT 509. Kindly come to page 57. Second paragraph. The learned junior standing counsel, however, lordships got that.
Yes.
However, submitted on earlier occasion that specific order was passed by the competent authority of the government of West Bengal, allowing the opposite party to retain land under section 6(3) of the West Bengal Estate Acquisition Act. And in order to enable him to produce a copy of the said order, hearing of the matter was adjourned. Today, he frankly admitted that no document has been supplied by the officers of the state government wherefrom it would appear that any order was ever passed under section 6(3) of the West Bengal Estate Acquisition Act, allowing the opposite party to retain any land. For the aforesaid reason, he submits that the impugned order passed by the learned tribunal cannot be assailed on any valid ground. We are also of the opinion that the learned tribunal has rightly held that no proceeding for resumption can be started by the state of West Bengal, as no order was passed under section 6(3) of the West Bengal Estate Acquisition Act on earlier occasion, allowing the opposite party to retain the land in question.
Right.
For the aforesaid reason, we do not find any scope to interfere with you.
This is the resumption order relating to this is the resumption order until 1st February 2000. This finding is returned against the resumption order of 1st February 2000. When they issued a notification under 6(3).
Yes.
Then the High Court says that, look, there is no order of retention, therefore the resumption is illegal.
Yes.
That is the finding.
Yes.
But we are going up a stage back. The first, the list of dates that refers to 1955, 15 April 1955. When the first time by operation of the Act, this land vested. What are the classified land under that at that point of time?
Well, that would appear from the portion.
Kindly compare that with the land that is sought to be resumed under section 60 now. These are the two things. What is the schedule of this land? That has been given 6(3). The land which was sought to be resumed, that schedule is there.
That, my lord.
That schedule is there. That we have checked.
এদিকে এসে বলো তাহলে।
In the order itself, it was there. The schedule was mentioned there.
I will tell you, lordship.
Yes, it's that way.
Page 50, my lord.
Page 41 is the schedule given.
Page 50.
41 of the paper book.
Yes.
509, page 40.
আমাদের মতো করে বুঝতে পারবো না, নিজের মতো করে করতে পারবো। Seen the schedule, page 41.
Yes.
And this was the land to be reduced by 6-3, by an order of 6-3.
Yes.
This is the schedule of this is the plot info. We just want to ascertain that what was the retained land when initially the land was vested by operation of the estate act.
108. Initially retention এর orderটা কোথায়? হ্যাঁ তো নন এগ্রিকালচারাল টেনেন্সি তো রিটেনশনের স্কোপ নেই, ভেস্টিং হবে না। I will check it up, my lord, because
That is the specific
this were not
for the tribunal.
very well, my
The
lord.
second paragraph records your standing.
These were non-agricultural tenancy. That
It
is
was retained as a non-agricultural and what were the plots involved? That is the only thing we are trying.
That will be in your client's favor.
Lordship. এই সময় নষ্ট করে লাভ নেই, দেখে এসে বলো। তাহলে মিলিয়ে নিয়ে এসে দেখে বলো, এই পরে কোনোদিন আটকে হবে। ওদের অপোজিশনটা দেখতে এটার সঙ্গে এটা কম্পেয়ার করতে আর এটার সঙ্গে এটা in any event they are not there, my lord. Maybe come back on some other day, because
And kindly notify the state also. They should also take a consistent time that this is our defense or this is our
We will record an order, Mr. Mitro. If the state they do not come, we can't force them to come. We'll close the hearing. Oh, you are there.
My lord, I am for Saraswati Press, my lord.
Oh, Saraswati Press. We'll record. This order should be communicated to the learned advocates. Only thing I find that page 56.
difficulty because Mr. Dotto warned before the trial, before the single judge also.
As page 56 of this, the order of Justice Pranab Chattopadhyay.
Yes.
One Mr. Shurojit Nath Basu had appeared. If you look at it, do you know him?
we'll have to find out.
Esho, Lego.
Basu's prevail, that is why possibly my lord, it became Basu.
That was a good one. We have heard Mr. Mitro Kamaladit, Senior Counsel, appearing for Free India Dry Accumulators Limited for some time. Stop. No, we do not find anybody present on behalf of the state. Paragraph. This matter will be listed again immediately after the Puja vacation, whenever this bench is again available. Stop. We request Learned Advocate General to see that some learned advocate represents the state on the next date. Stop. The paragraph, the matter will be displayed in the cause list at least 2 days before the next date of hearing. Paragraph, learned advocate on record for the appellants in
509.
FMA 509,
We are the appellant, my lord, in 509.
MAT 509 of 2019 is requested to communicate this order to the office of the Learned Advocate General.
My lord, would it be my lord's pleasure to record my lord presence at least?
Your presence will be recorded in the order.
Very well, because your lordship said the state is not present, so I am for Saraswati Press, if your lord.
Yes, you give your appearance.
Right.
You want us to record your submission?
It's not very clear.
I'll find it.
Hey.
Should we know ওইটাই হচ্ছে? That is the only query, my lord.
That is the only query.
আচ্ছা, ওইটা শুনে এইভাবে করো তো, we request Learned Advocate General or any other learned advocate designated by him to be present. বলেছি তো একটু লিবার্টি দিয়ে থাক। কেটে দেবো ওটাকে আসতে বলবো তাহলে শোন এই অভিজিৎ or any other কেটে দাও request the learned advocate general হ্যাঁ না আগে তো ওটা ছিল না learned advocate general to represent the state on the next date on the next date.
Grateful, my lord.
ভুল না হয় করা যাবে না না আমাদের সঙ্গে ও এই চল এ কোথায় আমাদের দাদা
Item number 5.
বললো 5 to 12 the same matter এইটা আমরা না এই 8 নম্বরটা 8 নম্বরটা দিন take up the 8
These are those signboards.
মানে the flyovers ওই পায়োনিয়ারটা দিন পায়োনিয়ারটা she dealt with the third item pioneer we also want to place that for the case my lord with all the order the same order common order in all the cases
8 was hard because
8 was hard. We don't remember.
no she will remember immediately because she can remember just she asked me on the last occasion to give the short fact and my lord the come with the also the
Yes,
written notes. We have prepared so and I am submitting to Lordship my lord this is the matter that there are several numbers of flyovers. The flyovers have been erected within the Kolkata municipal corporation territory area. And there is a certain process, my lord, for the purpose of erection of the flyovers. The government approval and all the things are there. The Howrah Beach River Commissioner, my lord, they have erected that. They are governed by the the Hooghly River Bridge Act. Then the construction has been made. Then question is, what is the power given to them after the construction of the flyovers? Now here the issue was that, my lord, that the Howrah River Beach Commissioner, my lord, Hooghly River Beach Commissioner, my lord, my lord, issued the notification, notice inviting a tender for putting up the hoardings on the flyovers. So they are giving the rent and they are taking money from the persons, my lord, who are putting up the advertising agencies. Now, since it is within the area, the whether, my lord, they have been vested with the power to give permission for erection of the hoarding in the flyover. Whether the power has been vested under that act also, the Hooghly River Bridge Act, whether power has been vested to them to put up the hoardings within the municipal area, that power has been given or not. So far as that issue is concerned, that need not to be, my lord, considered by your lordship because the court has said that this power is solely vested with the Kolkata Municipal Corporation and they shall give the permission for putting up the hoardings and the agencies are required to obtain the permission and to pay the taxes. Well, they have not complied with that. Well, that issue we have, they have not acted on that basis. Now, the question is, that again, they have given that the notification once again after the order of the single bench for the same purposes. One purpose was there, that they are putting up the hoardings.
May I come back?
But first question, whether the permission can be granted or not. The major issue, which have been, the argued here, or the honorable single bench did not, accept our point, that whether the land utilization charges to be claimed by the corporation or not. Land utilization charges, in effect, is a rent of the land which is being used. That is the issue. One issue, regarding the permission to put up the hoardings within the municipal area. If that permission, if they want to require it, I am to give it. If I give the permission, that is all right. They are taking the permission and running it. And if I do not permit to put up any hoarding on the flyovers, then the question of LUC and all other things, that does not come at all. Now, the question is, that the court has held that 202, 203 and 204, which are the advertisement provisions are there, they have to comply with that. The second issue, the flyover has been constructed on the land belonging to the corporation. I submitted the last occasion, before lawsuit, that under the Municipal Act 343, all the streets and all other things are vested upon the corporation. The question came before the court, they are vested to the limited purpose or not? Maintenance, control and all other things. This honorable single bench has considered two sections of the Hooghly River Bridge Act, 9 and 23. On interpretation, court has said the land vested to the Hooghly River Bridge Commissioner. Well, in my response submission, but that interpretation which has been given by the honorable single bench is not correct, because that the land which ultimately vested to the corporation, that has to be divested, then again it will be vested. And that section itself, 23, does not say that vesting of the land within the area of the Kolkata Municipal Corporation to the Hooghly River Bridge Commissioner. That cannot be the section itself on interpretation. And 9 also specifically provides that the bridge is to be maintained and controlled. No other power has been vested with the Howrah River Bridge Commissioner, Hooghly River Bridge Commissioner. And the question only remains that I have checked up, that there is a provisions in the Kolkata Municipal Corporation Act regarding the claiming of the rent on the land belonging to the Kolkata Municipal Corporation. Now, if your lordship consider that whether the land vested upon the corporation, the streets and all other things, whether it has got the proprietary rights, that was the last, your lordship, the issue comes for consideration. I'm just giving it, in a nutshell, the entire issue. I have checked up the act also, my lord. Apart from my interpretation of section 343, 344, and all other provisions are there, I have checked up and found that 1951 Act, that chapter itself says that the proprietary right on the corporation. And therefore, my lord, when that power is given, and under the present Act 1980, 635 specifically provides that the all rights, ownership and all other things, my lord, upon the corporation, that will continue. Therefore, it might not be necessary as and when the Act is amended, and every time it is to be recorded that the property rights, my lord, on the Kolkata Municipal Corporation. Now, you will also come to, I don't know whether they have prepared the notes of argument, but I tell you, lordship, my lord, that logically, your book is possibly the Hooghly River Bridge Act is there possibly in your lordship's, my lord, brief.
You are referring to the pioneers matter.
Pioneer matter.
এই ফাইলে নেই, HRBC অ্যাক্ট থাকবে, একটা জেরক্স কপি থাকবে, হুগলি রিভার ব্রিজ কমিশনার্স অ্যাক্ট।
পেপার বুকে থাকবে না এভাবে আলাদাভাবে দেবে হ্যাঁ
In this matter, no paper book was filed, huh?
No, because the entire paper is Malad.
Yes, yes, correct. No. এটা আমি নিয়ে নেবো তোর ঘরে কত যাবো ছুটিতে
এই আছে
আশা করে রাখবো Corporation matters.
I'm appearing on behalf of the HRBC, Lord.
In all the matters.
All the matters.
And for the appellants, one is Mr. Basu, and the
No, Mr. Basu is for the writ petitioner respondent.
sorry, for the writ petitioner. How many writ petitions were disposed of?
8.
There are 8.
8.
7 is here, probably. In today the matter lists 8 matters.
So today there are 8 matters in the list. You appear for whom?
I'm for the writ petitioner respondent. In all the 8 matters.
So 8 different writ petitioners.
8 different writ petitioners.
You appear for all of them. Very
Different
good.
agencies in different Malad flyovers.
I see.
Yes, yes.
He takes up the in the meantime. I have one copy. My difficulty would be.
No, you had given us, we remember. এ ভাই ভালো করে দেখে নিও
He takes it up for the time being.
You will carry on till 3:30. We can release the other matters then. Mr. Shamunto is waiting. Mr. Bera is waiting. Next day when we sit.
I want papers are all but the data is very
Basically, see the first Malad the preamble part, whereas the Hooghly River Bridge Act 1968 providing for the construction Yes.
Yes, Mr. Gore.
The original.
My lord, my lord, may I be excused, my lord?
Yes, excused.
My lord, only my lord, item number 18 I mentioned. My lord, yes.
May not be possible, sir, today. Next day we'll see.
One innocuous prayer that the corporation people will not visit again without the specific order of the court. Ransack the premises.
Unless the matter is taken up, sir, we can't. Just like that, we cannot pass an order.
For the
You maybe we are hearing a matter, Mr. Banerjee.
as he's mentioning.
No, but you need not come in.
Only thing that for short protection, they will not visit my place. They're ransacking the place in absence of the male members of the family.
Yes, Mr. Ghosh.
Theologically, the original act was in 1968. Then it was reenacted in the year 1969. The first you can say an act to reenact with modification the provisions of the Hooghly River Bridge Act 1968. Whereas the Hooghly River Bridges Act 1968 providing for the construction, maintenance and control of bridges across the river Hooghly within the port of Calcutta was enacted by the President of India during the period of operation of the proclamation issued by the President of India on the 20th February 1968 under Article 356 of the Constitution of India in relation to the state of West Bengal. On that basis, this reenactment of the Act of 1968 was made. Now, the court has considered, can see the section 9. There is a consideration regarding the power of the commissioners. Functions of the commissioners subject to the provisions of subsection 1 of section 3 and section 30. The function of the commissioner shall be to construct bridge or bridges across the river Hooghly according to such design of such material and equality and quality, and at such place or places together with such approaches as the commissioner may, subject to the approval of state government, consider suitable. This is power for construction of the flyovers or bridges. Then to maintain, control and improve such bridge or bridges together with the approaches. These are the power of the commissioners, my lord, under section 9 of this act. Now, and the another section which has been considered is section 23. Whether this section really say that whether it is vested upon the commissioners or not, land and structure bridges when to be exempt from or when to be liable to municipal taxation. This is, my lord, really in my respect submission. The land and the structure of bridges when it could be, my lord, exempted for payment of taxes. Lands required for the construction of any bridge under this act, including its foundations, approaches and slopes, or for any improvement thereof, together with all structures on such lands forming part of such bridge, which vest in the commissioners. My submission, the bridge vested after the construction, not the land. The bridge which is constructed, the court has interpreted in other way. The lands required for the construction of any bridge under this act, including its foundations, approach and slopes, or for any improvement thereof, together with all structures on such lands forming part of such bridge, which vest in the commissioner, shall be exempt and shall not be exempt from the rate or rates leviable under the Calcutta Municipal Act 1951, the Calcutta Municipal Act 1923, as extended to the municipality of Howrah and the Howrah Municipal Act 1965, the Bengal Municipal Act 1932, or the Chandannagar Municipal Act 1955, as the case may be, according as they are not. If it is, my lord, shall be exempted as they are not, and if it is, shall not be exempted if they are. If it is, my lord, let out to some other person, let out to tenants or otherwise utilized for deriving income. But this is only for the purpose of whether the municipal taxes to be paid or not. If it is let out, then not. Let out if it is let out, then, my lord, it is to be paid. And if not, then, my lord, exemption is there. that one of the two sections have been interpreted by the Honorable Single Bench. And my answer to this, my lord, I have given, my lord, in my written notes to this extent, my lord, that the section 23, my lord, does not say that the lands required for the construction of any bridge vest in the commissioners. What is vest under the act is the bridge which is constructed. This section 23 actually indicates that the lands and structures on bridges when to be exempted or when to be liable for municipal taxation.
Would the bridge be otherwise liable to be taxed?
Bridge.
The structure, yes, the bridge.
The structure not liable to be paid.
Only the land.
Land.
So therefore, whether structure vests or not is not of any relevance. For the purpose of taxation, whether land vests or does not vest.
It is in case, whether why it is said so that regarding the exemption of tax. But if it sometimes, my lord, it may be erected, the covering the land belonging to the private persons. Actually, my lord, on that context it is said. Not for otherwise. But if the bridge is there, corporation is going to, my lord, ask for the rent to be paid by the Howrah River Commissioner. Hooghly River Commissioner. Well, the persons, my lord, which owning the land, whether he is to pay the tax or not, this is the issue. The person who is owning the land, whether it is to be exempted or not. If it is let out, then it is to be paid. If not, the tax is not required. The whole purpose is that. The question is who is owning the property and who is required to pay the tax. But my submission before Lordship, my lord, that having the power to raise the construction or bridge, the act does not say that the land is vested to the commissioner. Because otherwise, the section 343, Lordship looked at the section 340 of the KMC Act, that says that all the properties, streets and the other the properties within the Kolkata Municipal Corporation that vest upon the corporation.
Unless,
the only question.
Unless, I'm just thinking aloud,
My
Mr.
lord.
Ghosh. Unless the land vests in HRBC, HRBC can construct on it.
Because the approval of the government, but where is it necessary without permission, all this process has been completed. Not only that, with that power, he has not done that.
Your permission is also
Yes.
obtained. KMC's permission.
Yes, KMC, then approval of the state government, everything is there. In process, it has been done. Therefore, what right they have given? Well, unless that is given, they cannot make that construction. The state government approval is there. All papers are there. There is a dispute about all these things. Because if I do not agree, because it is also my necessity, I may have to agree to that, whether it is to be done, flyover is required in that particular place or not. Therefore, after that matter goes before the cabinet and cabinet approves, then the Howrah Review Commission comes in. Therefore, without the approval being given, my lord, the Howrah Review on its own, on the basis of that, cannot come within the territory of the corporation and start raising the bridges. But that issue, my lord, is not required to be considered. The issue, my lord, the consideration is, my lord, the court, my lord, considers section 9 and 23. Now the interpretation is to be made having regard to that particular sections of the Hooghly River Act and also the Kolkata Municipal Corporation Act. Therefore, whether the construction, the power, the commissioner, the power has been given under the Act only to maintain, control the bridges. But that does not giving them power to earn revenue from the bridges. More so, so far as the advertisement issue is concerned, that is absolutely the prerogative power, authority under the KMC Act with the corporation. That power, my lord, you will not find that they have the power to let out any portion of the bridge for the purpose of putting up the hoardings.
From where will this maintenance cost come to the HRBC?
My lord?
Maintenance cost has to be incurred by
But
HRBC.
that is the other modality, but that is not the, that is not the issue. That for with that earnings, my lord, they have to maintain.
With what earning?
But that, my lord, of course, then I'm to take it because that is the issue. The government
No,
grants,
we want to know.
government grants and other things, possibly it comes.
We are not going to conclude.
Otherwise, my lord, only on the basis of that amount, on the paltry sum, that regarding the maintenance cannot be done. Government involvement is there, corporation has to, because their roads have to be, they are not only the maintenance of the bridge, their road is there now on over the bridge.
Does the corporation play any role? Take instruction. Play any role in maintenance of these bridges? Does KMC play any role?
Regarding the road is purpose that is there.
The road.
A constructed bridge that the road is to be maintained done by the corporation. Beneath the bridge.
No, the road over the river.
To my understanding, my lord, it is done by the corporation.
Which one?
The road, bridge to
Beneath the road belongs
No,
to
beneath the
not
road.
the flyover.
Yes, the
bridge is
flyover.
there, maintained by the HRBC.
No, maintenance, the construction of the road. Maintenance part, the bridge, if the bridge is to be maintained, then automatically
The flyover is constructed by
that one
KMC.
I'm exactly, I cannot offend, I cannot say, my lord, regarding that. The road purpose is construction of the road is issue is there. But I see, my lord, that Dhaguria bridge I have seen, the corporation is, my lord, making the maintenance and all that thing. But Howrah bridge, the bridge which is constructed by the
Dhakuria bridge is not over Hooghly River.
The bridge which is constructed by them, whether that is done or not. But I am submitting to your lordship, my lord, in the context of the decisions taken by the honorable single bench on interpretation of 9 and 23. And then the question, my lord, came, if you lordship look at the order of the honorable single bench, the court said that heard the party, the moot point to be decided is whether the petitioner was liable to LUC to KMC as claimed in the impugned bills at page paragraph number 20 of the judgment. Paragraph 20 of the judgment. So fund malad issue is just put the question how the fund to come. That is provided in section 18 of the Act.
What does it say?
It says, my lord, the commissioner shall maintain a fund to be called the Hooghly River Bridge Fund, and credit shall be given to the said fund of any income derived from the grant from the government or any other source, loans from the government or any other source, issue of debentures, tolls collected under the Act, any other source as may be approved by the state government. Now, this is the way they can collect the fund for maintenance and all that purpose. Now, you shall see, my lord, the moot question, my lord, regarding the LUC to be paid or not. The court, my lord, so far as illogically come to, my lord, the land utilization charges. বলেছি
Land utilization certificate.
Not certificate, charges.
So land has to be used, then only charges will come.
Illogically come to the paragraph, my lord, these are not necessary because the court has held in favor of the corporation, section 24, paragraph 24, 25, 26, up to my lord 29. But the court, so far as this part is concerned, court has said that they have to take permission from the Kolkata Music Corporation. Basically, see, the one public authority, without having the power to grant permission to put up the hoardings, that public authority, my lord, issued the notice, inviting tender, taking money, and the agency, my lord, putting up the hoarding there.
No, that is the
I
moot,
cannot-
Mr. Ghosh, the moot point is whether or not they have the right. That falls for determination.
That right of, my lord, putting up the hoarding. But that has been held by the court in our favor. In this judgment,
In your favor.
yes, 202, 203, 205 permission license, all must to be taken from us. Court has categorically said there is a dispute on that. The question is, my lord, that when I consider the question of land usage charges, first of all, we have to see, that is I raised an issue. Not the LUC is to be considered independent of the right of giving the authority to put up the hoardings within the municipal area. Unless that is well decided, because it is to some extent is correlated. Of course, well, secondary consideration is whether I can collect the LUC or not. Therefore, you can see the paragraph the court has said. I'm just pointing out to you, Lordship, my lord. Even you can read the paragraph 30, the court has said on conjoint reading of the opposite section means, my lord, 202, 3 and 4. The following points emerges: KMC cannot impose any tax unless permitted by law. All income from the taxes, cesses, fees, charges, etc. should be provided for in the budget of the corporation. KMC is empowered to levy tax on advertisement only in terms of the provisions of the Act and the rules and regulations prescribed thereunder. Section 202 prohibits advertisement without permission of the Municipal Commissioner. 203 empowers the Municipal Commissioner to grant license for advertisement and display the hoardings, and such advertisement should be in conformity with the terms of conditions of the license. Advertisement tax should be paid in terms of section 204. It is also mandated by the statute that the license fee, the advertisement tax should be at the rate framed by the regulation and or as reflected in the budget estimate under subsection 3 of section 131. Thus, the law mandates that the taxes, cesses, fees, charges, and charged by the KMC and the KMC should be reflected in the budget and should be claimed in terms of the Act, unless Act and the rules and regulations prescribed thereunder. The scheme of the KMC Act does not empower the corporation to claim land use charge. Therefore, so far as those issue is concerned, the power of the corporation is not disputed. And I have also, do not find any provisions in the Howrah Hooghly River Bridge Act that any power has been given to put up the give an advertisement, to put up the advertisement in the bridges by the corporation, by the commissioner.
Assuming what you say is right, that you have the right or power to claim LUC, is there any guideline, any rule, anything on the basis of which you may raise your demand? Otherwise, it will be arbitrary.
No, that I am submitting to Lordship, that is I am submitting to Lordship.
And one more thing. Section 23 of the HRB Act contemplates that HRBC can let out the land which is required for construction of the bridge and earn revenue. If they do so, they will be liable to pay tax to you. This power that they have been given, wouldn't it subsume that they can also let out the land and invite people to put on whatever placard, or maybe they will have to pay also advertisement tax to you. That is a different question. But whether HRBC would have the power, otherwise, what does this power of letting out mean? Section 23 says so.
23, that is, I'm submitting to your lordship. Section 23. Section 23. You can see one of the lands, your lordship, it is one of the, as I understand, one of that lands required for construction of any bridge under this act, including its foundation, approaches, and slopes for any improvement together with all structures on such lands or being part of such bridge which vest in the community. But my interpretation that land is not vested, the bridge is vested. And so far as the land which is used for the purpose of construction of the bridge, if that land is let out by some by any authority, then, my lord, regarding the tax to be shall be exempted tax and shall not be exempted tax.
So, of course, the problem is the structure, the bridge, having been built by HRBC, would be owned by HR. It will be HRBC's property. No question of vesting of the bridge.
Bridge is, my lord, the power. Bridge is constructed, and the power has been provided in the act itself.
And the concept of vesting relates to land. Always, we have never say structure has vested under the West Bengal Estate Acquisition Act or whatever. Is the land which vests.
You know, you can see the section. Well, section, you can see, my lord, section what that does it say regarding exemption of tax part only. The section, my lord, the heading of the section 23, lands and structures of bridges going to be exempt from or going to be liable to municipal taxation. But it does not say about the vesting of the property. Because the vested property is vested on me. That property, one public authority is vested, then how it could be vested again? Mainly because of construction of the bridge. Under my act, right from the very beginning, 1875, 1923, 1951, 1980 Act, the streets and all other things vested on me. Therefore, simply because, my lord, the purpose of
KMC Act 1980 আছে?
KMC is special statute, but overrides. The special statute, KMC is a general statute.
অনেকক্ষণ তো বলবে।
Arbitrary.
Well, you see, section 343.
Yes.
And then, my lord, you see, section 344.
Let us logically just think. We are having a discussion.
My lord.
Under the older corporation acts, all public streets vested in the corporation. Also on the 1951 Act, there must be a section, I'm not sure.
Yes, yes.
When 1968 Act was promulgated, HRBC, 1951 Corporation CMC Act was in operation. Till the promulgation of HRB Act, no confusion that the public streets remained vested in corporation. Then section 23 comes in, the 1968 HRB Act. The question is whether the land required for building a bridge over river Hooghly vested in HRBC or continued to vest in corporation. Even assuming that one interpretation is that the land vested in HRBC by reason of 23. Then again 1980 KMC Act came. KMC Act in 343 says all public streets will vest in corporation excepting those which vested in the government, the Board of Trustees, Kolkata Port Trust, or the Board of Trustees for Improvement of Kolkata.
Well, specified.
Specified.
Authority has been specified.
That's what I'm trying to say. Here HRBC is not mentioned.
Not mentioned. There is no authority has been specified.
Mr. Basu, for your response also, even assuming under HRB Act, the land, concerned land, let us say, vested in HRBC, again by a subsequent legislation, 343,
Expressly excluded something.
some,
Expressly excluded
some,
something.
but not HRBC. You address,
Yes, yes.
all right.
What is the overriding effect of this act, Hooghly River Bridge Act? You
I
said
say
it has a
special statute. If the two statutes is holding the field, the special will prevail.
Especially this has not given an
No.
overriding.
If my submission would be that if two statutes are governed in the same field, the special statute or the general statute will apply.
Calcutta Municipal Corporation Act has overriding effect. Mr. Ghosh?
No.
But the Calcutta Municipal Act
Has been given the overriding effect or no?
Perhaps not. On the contrary, look at 599, section 599.
599.
Perhaps there is no overriding effect.
It says that other laws not to be disregarded while acting in terms of that order.
To be
It is to be noted. No, no, it is to be noted. That does not mean, my lord, the provisions of the other act.
I'm not saying so. I'm saying
No, no, my understanding, as if my lord says that that is the issue.
I am saying simply.
No, my lord, it is always, my lord, other laws, my lord, while
Corporation is general law so far as
while
Kolkata is
implementing
concerned.
that order, question, my lord,
HRBC Act is a special statute for a specific purpose.
Howrah, which, my lord, the commissioner, my lord, comes into the Kolkata municipal area only on the issue, my lord, the construction of the bridge after getting the approval of the authorities, by the Kolkata Municipal Corporation and the corporation. Otherwise, they had no authority to come to our place. The whole question is, my lord, the land belongs to whom? and whether the simply because having the power to construct and to maintain that with the fund as provided under the Act, whether they can claim that the right of ownership also, along with that all through the all throughout the bridge moves on, the entire land belongs to the HRBC. That can't be. That and even that is so that I cannot use the underneath of the bridge. Because
Foundation
bridge
is not on the earth. My foundation is on the bridge.
তোমার কথা হচ্ছে না, তোমার তো bridge.
So I am not using the land. Even if ballot is vested to corporation, the bridge is above the land, and my foundation of the board's foundation is on the bridge.
What is the source of LUC? That is not very clear.
Source of?
Can you see the language?
Source is
Land
if
utilization certificate.
it is let out, so illogically consider when leaving aside the bridge part. Bridge part I am leaving for the moment.
Mr. Ghosh, kindly clear us. Unless there is an authority of law, you cannot levy. What is the source of levying LUC? Where from Corporation Act, which provision empowers?
Well, if it is my property, LUC is nothing but the rent.
Where do I get that?
But I'm just pointing out rent of the land, rent of my property.
That we cannot interpret. It has to be specifically there in the Act.
I'm coming to that. Just I'm giving that overall my thinking that land utilization charges the rent. Rent is to be collected. That the other way also the question come that the right of the property. Now, ecologically sees that my right to collect.
Yes.
Ecologically come to section 539. Ecologically come to
In the statute, rules, notification, where the LUC has been mentioned and where it has been defined. Unless defined, suddenly you can ask someone to pay on account of this head.
but definition of my lord.
LUC.
LUC means that is I'm sorry. LUC means the rent. But in the budget it has been mentioned the LUC land utilization charges. Whenever anybody utilizes, if I give it.
Mr. Ghosh, kindly see the law just indicates that it has been mentioned in the budget without bereft of any statutory force. But again, that will apply to footpath, portfolio pillars, and other permanent structures. Hearing advertisement.
The structure which is
property.
But
that structure also needs to be a property of
the claim similar structure of the property because the structure, the bridges which has been erected on the Kolkata Municipal Corporation land. No matter where.
Structure is not your property.
No, structure is not my property, but the structure has been raised.
You can levy LUC if it is the KMC property. That is even the budget says so. Schedule which states as
well. But that is the reason I'm saying if the KMC property, then the question first come whether I should give the permission or not. If the permission is not given, if they come to me to put up in the hoarding on the bridges, I may not give the permission. Then the question of all this issue regarding I can charge or not.
Now, can you claim ownership for the bridge?
I'm not claiming over the bridge. I'm claiming about the right of the land. Land on the basis of the land. The hoarding has not come. Bridge to the bridge. Bridge is on the land. Geologically, in the vacuum, in the air, it is not.
Your claim must be, it must emanate from a statutory right to levy. Well, levying something, where is the source of the law?
My statutory right, my lord, they first of all, I said, my lord, they cannot let out the any portion for the purpose of collecting the putting of the hoardings.
Not to be saying what they can do or what they cannot. You are asking a charge. You are imposing a levy. The nature of imposed, you are saying that it's LUC. What you are on that, where is the statutory force, statutory authority to impose this levy?
But levy. I'm submitting, my lord. I'm submitting, my lord. This power has been given under section 539.
What is their right? What is their
I'm submitting, my lord. If the property belongs to me, the question whether the property belongs to me or not. The land.
The land belongs to you.
If the land belongs to me, then something has been put up. The bridge has been put up.
No, Mr. Ghosh, if the land belongs to you, automatically you can impose the levy. Where from this proposition comes, then whatever I can charge, I can ask anyone from the being a statutory authority.
No,
Then
if
this
the,
is my land, if the aeroplane flows over me, how do I charge for that? There has to be some basis, authority of law to say this.
but it is attached, but the bridge is attached to the land on the that is what the advertisement is, the hoarding is put up on the bridge.
We don't mind if the statute says so. Sorry, Mr. Ghosh, sorry. Mr. Ghosh, if you are employed by the statute, if the statute says you are entitled to pay charges, of course. But
Well, I'm submitting to that. If it is, if
what
the,
you are submitting, that has to be a statutory backing first.
but my statutory backing, I tell you, Lordship, my lord, if the property belongs to us, if the property vested on me with a right of property right, then my lord, the somebody is putting up any hoarding, maybe on the bridge constructed by the Howrah River Bridge Commissioner, and that is on the land, but the structure embedded with the land, with the corporation land. Now that my lord, on that my lord, the bridge my lord, he is putting up the advertisement. Then can I not charge the land user charges because this?
Can charge anything provided the law permits you to do so. Automatically you cannot.
My lord already তোমার মুখ সে মুখার্জি বলেছে এরপর অন্য কিছু বলে বন্ধ করো
Kindly accept my apology.
No, it's all right.
don't hear to me between us
No, it's all right.
Mr. Ghosh, when I was in practice, fairly junior, I will not name the judge. He was a very nice, very friendly judge. Court number 5, I remember. I am appearing with smiling face. Yes, Dr. Chaudhary. Mr. Banerjee, my lord. Yes, Mr. Banerjee. After 30 seconds. Yes, Mr. Shengupta. Then finished with Mr. Shamunto. I did not try to correct him.
But that is also when I never make any statement for correction of the thing. What are the things?
One advocate with a very embarrassing face mentioned a matter saying that look, my name has been recorded as Koala.
that intentionally written by just super confused I can name Gopal Ghosh he said Gopal Goala the court officer what he can do he thought his name is Goala
He mentioned
to call regularly has been called as Gufo boss fortunately they have not been gone to the minutes.
Mr. Alok Ghosh, learned senior counsel appearing for Kolkata Municipal Corporation, resumes his argument but does not conclude. Paragraph, list the matter once again immediately after the puja vacation when this bench is again available. Now. So we'll record separate orders in all the other matters?
Yes, not benefit me, may benefit him.
Yes, separate orders, same order.
Share from him.
বুঝতে পেরেছো? 8টা ম্যাটার আছে। করে দিই।
Miller, on the next date, Miller, we will be filing the notes.
দাঁড়া শেষ করো গলকদা।
Yes, file. You have not filed your note today.
Not yet filed, my lord. Then
all right.
দাদা ওটা কি রেকর্ডে রাখছেন?
এটা মুখার্জি চলে
রাখছেন ওগুলো?
ও যাতে তুলে দিল গোয়ালা থেকে মুখার্জি করে দিল। বিজয়
HRBC একটা রাখলেন? HRB একটা রাখলেন? এক্সকিউজ মি স্যার, HRB একটা রাখছেন?
আমরা জেরক্সটা করে চেক লাগিয়ে দেবো।
একটা কাজ করুন না, একটা রেখে সেটাই জেরক্স করে দুজন জজ সাহেবের করে নিন, আমাকে একটা ফেরত দিন।
আচ্ছা ঠিক আছে, ঠিক আছে, পরে তাহলে নিয়ে নেবেন। পরে এটা নিয়ে নেবো
লার্জার বেস আছে
বলো
দেখি তাহলে আটটাগুলো একটা কিন্তু নতুন ঢুকেছে কালকে নতুন একটা ছাড়ো আর বাদ বাকি হলো তাড়াতাড়ি হয়ে যাবে আচ্ছা ওই তারিখেই হবে
আজকে কি দিতে পারবেন নাকি?
আজকে পরে পরে নিয়ে গেলে সুবিধা হতে
ঠিক আছে তাহলে মঙ্গলবার না বাবা?
হ্যাঁ হ্যাঁ আমি একটা জেরক্স করে রাখছি করে মঙ্গলবার দিন
সুবিধার কাছ থেকে নিয়ে নেবো
হ্যাঁ,
60 টাকা।
একদম
কিন্তু আপনি একটাই পাবেন না এই জন্য যে ক্যাম্প পাওয়া যাচ্ছিল না ওটাও আপনারই অর্ডার
আচ্ছা
হ্যাঁ 932 প্রথমটা
স্যারকে পাঠাতে হবে
বলে দিচ্ছি কালকে ঢুকেছে 932 বলে
932
ওটা তো প্রথমই ছিল গো
হ্যাঁ দু নম্বরটা হ্যাঁ মানে পাঁচের পর
অ্যাসাইন করালাম কিন্তু হয়েছিল বুঝলে লকডাউনে ক্যান পাওয়া গেল না জেরক্স কপি নিয়ে অ্যাসাইন করানো
এটাকে একটা দিয়ে গেল এইটা হ্যাঁ
দিলাম সব কিছু তবে নেক্সট ডেট
এটা বলেন
একটা লার্জার বেঞ্চ কি দেবো অ্যাস লিখে দেবেন অ্যাস লিখে দেবেন দেখে কারেকশন নেই নম্বরটা সেম অর্ডার হবে
হ্যাঁ হ্যাঁ হ্যাঁ
এবার ডাকলাম দেখে কিন্তু না দাদা এখন আমাদের সাবমিশন নয় দেখি তো কেন বলছি আমি জানি না দু নম্বরটা বলো না সেম অর্ডার
হ্যাঁ সেম অর্ডার
কালকে যে দুটো অর্ডার হয়েছিল
না না
ইনভেনশনে অনেক আজকাল সম্পূর্ণ সম্পাদিত